a junior officer because we couldn't go to the mess together. So I opted out of prison service so that she could stay. So I joined the Internal Revenue Service, where I was the legal officer in charge of Eastern and Volta regions, also for 2 years. Then finally joined the bench in 1992 December, and the rest is history. So I was posted to Yaya as a circuit court judge, brought to Kumasi. For 7 years, I was circuit court judge, and I became high court judge, and then I'm now here. So I've been a Supreme Court judge for the past 17 years until 22nd of April, when I was nominated to act as the Chief Justice during the period of the turbulence. And I'm here before you as a nominee for the position of Chief Justice. Now, if I may read my opening remarks, now that I've asked the first question.
Thank you very much. So, my Lord, beyond telling us about who you are, you indicated you have an opening remark. We've also seen your credentials. In giving us the opening remark, you should briefly describe the personal values and experiences that you believe most qualify you to serve as Ghana's Chief Justice.
Thank you.
You combine it with your remark.
Okay. Honorable Chairman, it's a profound honor for me to appear before you today as nominee for Chief Justice. The judiciary of Ghana stands at a defining moment. As I appear before you today to be vetted by Parliament, I do so fully aware that this process is not merely a constitutional requirement, it's a national reckoning. My nomination comes at a pivotal moment in Ghana's democratic journey, a moment marked by public skepticism, institutional fatigue, and a growing demand for justice that is not only delivered but deeply felt. As I step into this role, subject to your endorsement, the nation will look to me not merely to preserve the judiciary's legacy, but to renew it. The nation needs a judiciary that does not merely interpret the law, but elevates the nation's conscience. With your guidance and cooperation and that of all stakeholders, I pledge to restore confidence in our judiciary and leave it stronger than I found it. If I'm endorsed by you, I pledge to lead an era of greater transparency, efficiency, and accessibility in our judiciary. I do so mindful of the constitutional role of the judiciary, not as a political actor, but as a guardian of rights, checks against abuses, and final arbiter in the rule of law. I propose to anchor our transformation on 3 pillars: procedural clarity and predictability, efficiency and accountability, and open justice. If confirmed, I will stand with every judge, every staff, every court user, and every citizen in the belief that access to justice should not depend on who you are or your connections. The Constitution entrusts the Chief Justice not only with judging cases, but with guarding the credibility of justice itself. My task, if confirmed, is to ensure that the law remains both a shield for the weak and a restraint upon the powerful. With your guidance and cooperation, I pledge to restore confidence in our highest institution and leave it stronger than I found it. Now I'm ready for your questions. Throughout my career, from prison service through the Internal Revenue Service and the Judicial Service, where I've been for the past 33 years, I have integrity. I've believed that everything that I have done as a judge has been done with integrity, honesty, and impartiality. I have charted a course of adjudication that believes that the law should be the law for everybody, and that it doesn't matter who you are and what you are. Once it comes to the law, it is no discriminator of persons. That has been my abounding lifestyle. And if anybody were to go through any of my files at any of these places, this is what you come up with. That this man is honest, this man has integrity, and this man has what it takes to be a leader. And I believe that I have what it takes to lead the judicial service.
Thank you very much. That is preliminary. I will then proceed to give the floor to Honorable Roxanne Nelson Kwame Eche Dapamako to ask questions. Honorable Member, you are entitled to 3 questions. You may ask up to 3 questions.
Thank you very much. I'm guided. My Lord, you're welcome.
Thank you very much.
I wish you all the best.
Thank you.
And thank you for guiding me at the bar.
You're welcome.
My Lord, you have a very rich CV. But let me touch on a matter that is out there. What would you say to those who suggest that your nomination by the president was a reward for your holding in his favor in the 2013 election petition? It's some debate out there.
Well, I don't know. I don't know where to start from. I actually do not know. I wouldn't know what goes on in the president's mind since I'm not there. But I actually will be disappointed if my only qualification for the Chief Justice nomination is because I voted for the president in 2013. But that is on a lighter note. But I think I qualify for the position. As I said, I have been a Supreme Court judge for the past 17 years. I would not be presumptuous to say I am the best qualified person in the Supreme Court. No, I would say that. But I've been at the Supreme Court for the past 17 years. The person who has served nearest to me has been there for 10 years. Meaning I was at the Supreme Court in 2008. The next person came there in 2015. The others are from 2019 and then 2020. So I think I qualify for the position. And let me add something. I was actually, if you look at my CV and if you follow the trajectory of my career, I was actually admitted. I mean, I actually was made a circuit court judge by Chairman Rollins. Then I was promoted in 2000, and I was sworn in together with Secretary Jamefe. I was sworn in by the then Vice President, President Mills. Then I was elevated to the Court of Appeal by President Kufuor. Then to the Supreme Court by President Kufuor. So if, that was 2008. So if 17 years later, another president deems it fit to eliminate me to the position of a Chief Justice, I think I cut across all political boundaries. I don't think that, I think I'll be a reason for people to say that, oh, this man is deserving of the position. Because from Rollins, Mills, Kufuor, and then Mahama, I think I deserve the position, that's why. But as I said, the president might have no reasons. I don't know that.
Very grateful.
Any further question?
Yes, my lord, you have a very rich and expansive CV. I see that you've done, as part of your work as a juristic officer, you have also worked extensively in election and election-related matters, chaired a lot of committees. Now, the argument is out there regarding the duration that presidential election challenges take, all the 2 or 3 that we've had so far. Will you consider, if you get the approval of this House, will you consider introducing reforms such that, for instance, a challenge can be determined before inauguration on the 7th? Will you consider that? That is between the 7th of December and the 6th of January. Will you consider introducing?
Thank you, Honorable Chair. Thank you, Honorable Chair. You see, as part of the, as you said, I have been a member of the Election Management Committee of the Judicial Service since 2010. And then I became its chair in 2020. As a part of our engagements last year, we had a lot of stakeholder engagements with IPAC. We had stakeholder engagements with the CDD, CODEO, that is CSOs, and then the Peace Council. The main theme of these meetings was the fact that in 2013, the election petition lasted for almost, it was 8 months. The final decision came on the 29th of August. Essentially, I'm the only surviving member of that panel. Everybody else has retired. The final decision came on the 29th of August because one of the first drawbacks was we spent almost 1.5 months discussing whether to even allow the NDC as a party to join the action. In the long run, at the end of the day, by a majority of 6-3, NDC was joined to the action. It was one of the greatest mistakes we made in that particular trial. And that was one of the first things we touched on after the trial. We went into a conclave and came up with a decision that, no, there was a need to join any other party. So CI 99 came up, and that was when we decided that the trial and everything could be done within 42 days. So discussions went on, and we agreed on 42 days maximum for presidential election petitions. And so in 2020, when there was an election petition, it was a straight fight between JDM and then Akufo-Addo at the time, and then the EC. And it took 42 days to deal with that election petition. But we know that Kenya does theirs within 21 days. The only time America faced an election petition, that was between Al Gore and Bush in 2000. The election petition, whatever it was, ended with the declaration of the new president before the inauguration. So at most of these forums or fora where we discussed the elections in Ghana, we came to the conclusion that it should be possible to have the election petition concluded before the 7th of January, the inauguration day. And the first suggestion that came, which we think was a masterstroke, was that we should have the elections on the 7th or the 8th of November. If we have the elections on the 7th or the 8th of November, by the 10th, the results would have been declared. If we have the results declared on the 10th of November, we have 20 more days before even November ends. Then 31 days of December, then 6 days of January, making a total of 57 days. Assuming we want to stick to even the 42-day window provided by CI 99, we can have the election petition filed, responded to, and everything tried within the 42 days, because we have 57 days. That is number one. In addition to that, we can have, lawyers say that every originating motion or originating process has to be served personally on the defendant or respondent. But we all know that in this day and age, every form that anybody fills with the EC, you have to provide electronic address. You have to provide email, telephone, WhatsApp, and all that. So instead of saying that you file a petition and it takes 7 days to get to the respondent, using the electronic mail, we can reduce the number of days to, let's say, 3 days. So a process that is filed, if it is served electronically, even the originating process can be filed and served electronically within 3 days. Instead of waiting for, let's say, 1 week for the response, we can reduce the number of days for the response to, let's say, 4 days. So if we adjust times like that, by the time we get to about, let's say, the 30th of November, that is granted that we had the elections on the 7th of November. By the time we get to November ending, processes would have been, pleadings would have closed. CMC, court management conference would have gone through, issues would have been settled, and then a trial will begin. And a trial like that, we can say it should take no more than 2 weeks. And once 2 weeks are there, we say judgment should be given within 1 week on the release of the results. Meanwhile, at this point in time, during December, we have a lot of holidays. But under the fiat of the Chief Justice, the registries can be made to stay open so that processes can be filed, served, exchanged, everything can be done in such a way that we can have all these things done before the end of January, so that by 7th of January, Inauguration Day, we will have our president who will take the sword and swear to his people and be able to say, because we all know in 2013, for 8 months, the president-elect was performing his constitutional duty all right, but he wasn't too sure whether he was going to be chalked off or replaced or what. Even though the 2020 election petition also lasted for only 42 days, it lasted beyond the inauguration. So these are things that we have discussed, and we shall need the input of Parliament when it comes to LIs and CIs to be prepared. So this is what I intend to pursue so that we can have our election petitions, if any, in future. And I'm sure there will be, and before the inauguration day. Thank you, Mr. Chairman.
Thank you very much. Do you have any further question?
Mr. Chairman, thank you. That is so. My Lord, I appear to be the Lone Ranger in this matter. The welfare of the judges at the magisterial level is so dear to me. But I see a disparity in the welfare, in the service of office and conditions of office for what you term professional magistrates, that's lawyer turned magistrates, and the career magistrates. And they do a lot of work, the career magistrates. In some cases, they do relieving in 2 or 3 other district courts within their jurisdiction. So the question is,
yes,
will you consider introducing the career magistrate program to absorb young men who are interested? Yes, reintroduce, because it will be a very heavy source of personnel. And also reforming them in such a way that they will have the opportunity of rising through the ranks to the level. Because recently you just elevated...
Honorable member, I think you have
Mr.
asked
Chairman.
your question.
No, Mr. Chairman.
You see, today I said we'll go by the rules. A questioner is not supposed to run commentary. You don't run argument. The foundation cannot be too long. So strictly proceed to ask questions. That is the rule. So Honorable Roxanne Nelson Dapamokbo, ask question.
Chairman, I'm guided. Thank you. So, CJ nominee, will you consider reforming the courses, the career magistrate program in such a way that they'll have the opportunity of rising through the ranks and getting to the highest level? Because they do a lot of work as the same as the professional magistrates. Presently, you have about 75 openings at the magisterial level. You just elevated some from the circuit to the high court. Naturally, you will elevate the district judges to the circuit court.
Thank you, Mr. Chairman. In the years gone by, when we started practicing, we had the grade 2 magistrates and the grade 1 magistrates. And the grade 2 magistrates were actually not trained lawyers. Most of them were social welfare workers, retired teachers, and the rest. They were grade 2 magistrates. And then lawyers who joined the bench, but were not 3 years, also had to work as grade 2 magistrates. Her Ladyship, Justice Avril Lovelace Johnson, was a grade 2 magistrate in Chebi. I appeared before her when I was a lawyer with IRS in Koforidia. I used to appear before her. So that was, but when lawyers get to 3 years, lawyers who had joined the bench got to 3 years, automatically they became grade 1 magistrates. But with the grade 2 magistrates, the original ones, they never had the chance to go beyond grade 2 magistrate. They couldn't join the bench at any level because they were not lawyers. That was the situation of things until sometime, I think in the 90s, the whole concept of grade 2 magistrate was abolished, leaving only professional magistrates, that's lawyers who were magistrates. But then, around the 2000s, the millennium era, this concept of career magistrate was reintroduced. This time they were not called grade 2 magistrates, but they were called career magistrates. But they were doing the same thing. And this time, the judiciary went one step further. Whilst with the grade 2 magistrates, they were just social welfare persons who had retired or been drafted to become magistrates. With the career magistrates, these were they could be even as young as 30 years. In fact, they were the very first ones were actually workers with the judicial service who were drafted to undertake 1 year or 2 year course at the law school. So they took 2 year courses and then they were made career magistrates. But they are not lawyers. So the path carries them only to the chief magistrate level. And that was it. It doesn't matter how long you stay there, you can get to a chief magistracy, and then that will be the end. But we still maintained the 3 years for professional magistrates. So what then became the order of the day is that these lawyers, these career magistrates, then opted to go and read law. And once they went to read law, then they could transition to become professional magistrates. But here was the problem. You find somebody who has been a career magistrate for, let's say, 7 years, 8 years, 9 years, 10 years. Now he goes to the law school, he transitions, he's a lawyer now. And because he hasn't spent 3 years, he has to remain on the career magistrate level until he becomes 3 years. He gets to 3 years. Even though he might be more experienced than somebody who has left the law school and, been practicing for the past 3 years. So there was a problem. And then again, I know, for example, in the army, if you go through the rank of, let's say, the junior ranks, The furthest you can go is maybe chief warrant officer. But in the army, you find you have a warrant officer who, because of longevity, maybe even be receiving a salary higher than that of a captain at a senior of that level. But with a career magistrate, it doesn't matter how long you stay as a career magistrate. You cannot run an incremental that will make you overtake a professional magistrate, somebody who has joined just this year. All these were problems that, but as a number member was saying, only about a month or so ago, we had a send-off party for a couple of our retired career magistrates. And it was when their CVs, their citations were being read that we realized that we really need them. Because these are the people who are prepared to go to the nooks and crannies of the country. Maybe you are a magician, maybe you have been following the judicial service. But the vacancy at the district court is 116 at the district court. We are not getting lawyers to join at the magistracy, at the district court. Most of them want to come out to the circuit court and to the high court. So with the current elevation of some circuit court judges to the high court and the district court to the circuit court, we are going to have an opening for 116. And I can assure you, we are not going to get, no matter how often, how much we advertise, we're not going to get lawyers to come and fill these vacancies. So it is my project that I will be discussing with the Judicial Council, the reintroduction of not only the reintroduction of the career magistrates, but we should be able to have a proper remuneration regime for them so that those who come can stay. And then, again, it should be possible that there should be a law that makes it possible for somebody who has been a career magistrate for a certain number of years, if he becomes a lawyer, then he doesn't need to wait for another 3 years to become a professional magistrate. There should be a smooth transition. This is a project that I intend to pursue.
Thank you very much. I will then proceed to give the floor to Honorable Mahama Shaibu.
Thank you.
You are entitled to 3 questions, strictly questions. I can assure you, my Lord, that every member of this committee may want to exhaust the 3 questions. So, strictly questions, no comment. And non-members of the committee, I plead with you to perpetually remain silent.
Chairman, let me thank you very much. My Lord, congratulations. Chairman has cautioned, but my Lord, cost of litigation by the day has become very expensive. Legal Aid Commission came in as a stopgap. Unfortunately, they lack the resources to represent clients. So today you have in courts unrepresented litigants. Would you consider fashioning out a very simple procedure which can take care of unrepresented litigants? Thank you.
Thank you very much, Honorable Chair. The legal aid is an orphan. The legal aid board is an orphan. like the prison service. Now the prison service, they are getting some parents, but the legal aid remains in the doldrums. It is true that cost of litigation is now very high, and it's becoming very, very high. Higher as a result of the delays that are occasioned in the courts, so that even small, minor offenses in the criminal realm, small claims in the civil realm, still have to follow a long queue. So litigation is now very expensive. And when you look at the persons who patronize the legal aid, you realize that, but for the fact that they don't have the means, they wouldn't go there, because they are very much under-resourced. So it is something that I have discussed since I started acting. I have discussed with the Attorney General, and we are trying to find a way of resourcing the legal aid. As a matter of fact, with time, in the long term, we are thinking of even mobile courts, which will be able to take care of some of these things. We are thinking of, I was telling somebody that maybe the president even stole his the 24-hour economy idea from the judicial service, because we have planned for some time now to introduce courts around the clock, so that we can have night courts. And then, see, all these are supposed to augment the legal aid situation. If there are courts around to take care of cases, definitely the cost of litigation will go down. So apart from asking for more resources, which I have discussed with the Attorney General, we are thinking so much about other things like having night courts, weekend courts. Already we have weekend courts to take care of electricity and other things. So once we do that, we hope that, and then to cap it all, the ADR, ADR is something, an avenue that we want to highlight. Already we have court-connected ADRs, and then we have set aside weeks, 1 week in every term, to have ADR sensitization. But people are still not sensitized enough to resort to ADR in some of their claims. So we have a combination of plans to get rid of, to restore the legal aid and also reduce the cost of litigation. Thank you.
Thank you very much. I recognize a supplementary question from Honorable Mahama Ayariga, the leader of the House. You have the floor.
Thank you. So, my Lord, do you have your commitment that your court will now say 24 hours when you become Chief Justice? Judiciary at 24 hours.
I said we are exploring. Already we have. No, we
want to pin you down to a specific commitment to this committee that the courts will explore and will sit 24 hours and provide opportunities to citizens to pursue justice 24 hours?
Well, it is possible, but for now, we have some courts that have morning shifts and afternoon shifts. At least for now, we have that one. And we have some courts that sit over the weekends. So it is now left to us to, so we can say we have a 16-hour economy. It's now left to, with time, maybe we will get to a 24-hour. I'm certain the president stole his ideas from us.
Thank you very much. Honorable Shaibu, do you have any further question or follow-up on this question?
Thank you, Chairman. A further question, not a follow-up.
Very well. That is your question number 2.
My Lord, let's still stay within justice delivery. A very important aspect of how we live. Cases on appeal. I mean, previously, if you're up country, Bolga, Wa, Tamale, you would have to travel to Accra for Court of Appeal cases. I note that there was a system in place that cases were heard in Ho, Kumasi, Tamale, and Cape Coast. This, for some time now, has not been working, or it has been suspended. Would you consider that Accra is not Ghana, and that many regions still will have to travel to Accra to the Court of Appeal? Would you consider reinstating and possibly expanding that service to all regions of this country? Thank you.
Thank you, Mr. Chairman. I think with all due respect to the questioner, I think the question is not factually correct. Yes, we used to have Court of Appeal sitting in certain regional capitals that are not, where we don't have them now. But it is not true that all the other regions have been suspended, no. Now we have a Court of Appeal in Accra, as usual. We have a Court of Appeal in Kumasi, where we have accommodation. So they are residents there. The judges, there are 10 judges of the Court of Appeal who are in Kumasi, residents there, dealing with cases in Ashanti region, Brong-Ahafo, and the north. We have 5 dedicated Court of Appeal judges for Eastern and Volta regions. I mean dedicated in the sense that they are assigned to only the Court of Appeal cases from Eastern and Volta regions. So the Court of Appeal sits in Koforidua. Then a Court of Appeal sits in Sekondi to take care of Central and Western regions, and then the Western North. So we have at least 4 courts of appeal. That is Accra, Kumasi, Koforidua, and Sekondi. These are the 4 places that we have our cases. But whilst because there is accommodation for the judges in Kumasi, they are resident there. The dedicated 5 for Eastern and Volta are living in Accra, but they go to Koforidua 1 week in a month. 1 week in a month. They will go and sit there 1 week in a month. Then those who are for Sekondi also go to Sekondi and deal with cases 1 week in a month. Now, Tamale and the North don't have resident judges there, but they are also served by the judges in Kumasi. But you see, because of distance and then even costs, any time the 5-member committee, judges, the panels goes to Kumasi, goes to Sekondi, the service spends 38,500 cedis or 40,000 cedis on them in terms of hotel accommodation, transportation, and all other logistics. Koforidia, if the 5-member go, it's the same thing, around 40,000 cedis. But you see, going from here to Koforidia is so easy, even though it is risky and inconvenient. It is so short. The Kumasi people found it very difficult to go to Tamale, where they would meet the judges. So they were doing virtual hearing. The virtual hearing was started at the time of COVID, and we realized that it is a very good way of doing things. So Kumasi and the North were communicating only by virtual hearing. And then, but when I started acting, I realized that the virtual hearing was not very convenient because of the interconnectivity. There were breaks in transmission and other things. So I actually spoke to the Judicial Council. We went to see the Minister for Communications, that is Honorable Sam George. And now we have the interconnectivity is so good that even now we don't go to Sekondi again. We do virtual hearing of appeals for Sekondi. So now instead of incurring 40,000 cedis in a month, we do virtual hearing. So it is something that the lawyers are very, very happy about. For now, the judges stay in Accra, and then the parties meet in Koforidia. So even if the lawyers in the case are in Accra, they still have to go to Sekondi to take part in the virtual hearing. Now, what we are aiming at is a situation where we can have persons, for example, Kofodia and Ho. We are trying to get to a situation where lawyers will not go from Kofodia Ho to Koforidia, but they can also have a hearing whilst they are in Ho, so that the judges will be in Accra, the parties could be in, one of the parties could be in Koforidia, another party will be in Ho, or Cape Coast lawyers can sit in Cape Coast and listen in and take part in it. That is a long-term project, but for now, the regional capitals are taken care of by way of virtual hearing.
Any further question?
Yes, Chairman.
Please do.
I see my Lord is getting into virtual stuff. So let's move on to empowering of judges at the Supreme Court. First of all, what goes into the thinking when you are empaneling judges, and given that the human element of it raises some questions, would you consider looking at an automated system of empaneling judges at the Supreme Court? Thank you.
Yes, my Lord.
Thank you, Honorable Chair. Empaneling creates a lot of anxieties among people. There are lots and lots of people suspicions about for judge shopping, persons who are, some judges are not empaneled and other things. I think to get rid of such suspicions, we should be able to consider AI to do that. I am not very AI, but I know that those who know about AI tells me that if you are able to feed the computer or AI with information about judges, their philosophies and everything, the AI should be able to do empaneling based upon the things that we have fed it with. But, and I think it is done elsewhere, so we can try it. But what actually goes into the used to go, I wouldn't be able to say for some time now what. But when I joined the bench, when I joined the Supreme Court bench, we were about 16. And then when at the Supreme Court, we know everything is based upon seniority. We have persons we refer to as seniors. Then we have the middle, and we find the juniors. There is no derogatory. None of the words is complimentary or derogatory. It only shows when a person was appointed. So I will be most senior. It doesn't mean I'm the best. Somebody may be the most junior because he was appointed to the Supreme Court only yesterday. But that is how we had this classification. So any case, we had the seniors. So any case that we wanted to empanel, you find one senior. Since we sit in panels of 5, we have a senior, we have 2 middle, and 2 juniors. And that makes a panel. And it was done randomly. There were situations where if we are sitting in 7 and we want to believe that this is a matter that we should get the seniors to sit on, then it is that can also be done. I remember in the 2013 election petition, the empaneling was done in such a way that the Chief Justice opted not to sit on it. Justice Datiba had only 4 months to go on retirement. And since we were not too sure how long the whole trial was going to take, he opted out. Then it was number 1, number 2, number 3, number 2, up to number 9. So it wasn't like somebody had been handpicked from somewhere because of this particular reason or the other to do it. So empaneling is normally done randomly, or it follows certain patterns. But because of the anxiety it creates among people, the suspicions, or people feel it's not transparent, I I think we should be able to consider AI empaneling. But in our part of the world where a person can decide not to sit just about 2 or 3 hours to time because the wife is being taken to the hospital or the father has just died, it means AI will find it difficult to replace such a person. Maybe AI should be told that, okay, instead of 5, set aside 6. So when somebody opts out, you can bring this person in. So AI will be a very good thing for empaneling. Thank you very much.
Yes, Honorable Shaibu, your very last question.
Yeah, exceedingly grateful. Exceedingly grateful, Chairman. I see my Lord has veered into AI. Can we apply AI again or any other method? Backlog of cases and then delays. What concrete steps and time-bound steps would you want to employ to deal with backlog of cases that are hanging and speedy trials? Thank you.
Thank you, Honorable Chair. I think to tackle the backlog, to find a way of clearing the backlog, we must first identify what causes the backlog and then the delays. In the first place, litigation, courtroom litigation the volume has increased, whether we like it or not. Now, people litigate practically over everything. In the years gone by, I'm sure if you took my picture and you displayed it in your newspaper, and so I'll be very, very happy if somebody came and said, Daddy, I saw your picture somewhere. I will see it as even you promoting me. But I'm certain that if you displayed my picture in your anywhere else, maybe even in your house, and without my permission, I will sue you. So now people sue practically over everything. Intellectual property and everything. So the courts are inundated. That is number one. We've tried to solve that problem by opening more courts. But the more courts that are opened, the more the litigation comes up. Some time ago, we had courts up to Medina. From Medina, you could only go to another court on the mountains. Then we realized that we have to have a court at Adenta to take care of that enclave. Now, courts in Adenta have more cases than courts in the law court complex. The threshold for every court should be about 250 cases. At the last count, the High Court 1 in Adenta had 849 cases for one court. So the cases are many. There are more cases. So it doesn't matter how hard you work. You find you deal with one case and 2 more cases are added. Then we have situations which I will refer to as, institutional. CI 47 was actually passed in 2004. Those of us who were practicing using that, the older version of the rules, That was LN 140A of 1948 or 1950, 1960, 1954. LN 140A of 1954. Between 1954 and 2004, when the new CI 47 came, lawyers were always referring to the White Book of London, of England, which had undergone several editions. But we still had our LN 140 of 1954. By the time we had the CI in 2004, CI 47, it was already dead at birth. It was outmoded at birth. So we have rules in the CI 47 which make it impossible for us to move forward. In this day and age of electronic e-service and everything, we still say that when a person issues a writ, it has to be served within 8 days. Now we have the Electronic Act, which makes it possible for you to do a service electronically. But the rules insist that as far as the originating process is concerned, it has to be served personally. So you, in this day and age of when everybody fears for his security, we still have bailiffs going around serving processes. So if we improved the rules, we have situations where applications that are filed, applications are filed and they stall proceedings in the trial courts. All these things are catered for by the rules. So if we are able to review the rules, and that is one of the things that I intend to do, to engage the Rules Committee, the Attorney General's Department, the Attorney General, not the Attorney General's Department. I will be on his neck, and then I'm not going to kill him. I'm not going to kill him. I'll be on his neck, and then with the Rules Committee, so that we should be able to amend the rules to make it user-friendly, to take care of the technicalities so that trials can be sped up. As for the cases that are already in the back, that have been clogged, what we can do is that we should be able to track. Now we have a monitoring team which I'm going to reinforce, that should be able, that goes about tracking backlog cases that are locked up, and then we will see what we should be able to do about it. This is not to say that there are no human elements in this. Lawyers play all kinds of games to have cases delayed. They play all kinds of games to have cases adjourned. I remember when I was appointed a Supreme Court judge, and we were attached to the American Supreme Court. They were surprised that we could grant adjournments on the ground of somebody's wife, and because a lawyer says, my wife is being taken to the hospital. The judge asked us, are you a doctor? If your wife is going to deliver, you are the doctor, you don't need to be there. You have to come to court. And that is their system. But here, sometimes you have somebody coming to say, my father has died, 3 years later, he's asking for adjournment, and his father has died. 4 years later, the same father has died. How many fathers you have, you cannot really tell. So we see there's a human element to this, but we are going to work on all these so that we can have a reduction in the backlog of cases. Thank you, Mr. Chairman.
Thank you so much, my Lord, the Acting Chief Justice and the nominee before us. We have 6 more members to ask you a question. Therefore, we will plead that the brevity rules that apply to members would apply to you, mutatis mutandis. So I will call on Honorable Haji Aladi to ask you a question.
Thank you, Chairman. Chairman, let me take the opportunity to congratulate my brother on his being nominated. From your narration, you have clearly stated that you've come a long way through so many governments, presidents, vice presidents, and what have you. That is actually a basket full of a lot of experience, and your CV tells it all. However, although you are acting, you are now going to be the substantive, inshallah. My question is, as Chief Justice, you will preside over a Supreme Court with diverse personalities and differing judicial philosophies. How will you foster collegiality and prevent personal disagreements from undermining the administration of justice? Thank you.
Thank you, Honorable Chair. Well, Honorable Chair, by its nature, the Supreme Court is collegial. When we say collegial, we mean, unlike the, let's say, District Court, the Circuit Court, and the High Court, we sit in colleges, we sit in panels of more than one. So, and then we take decisions together. There is no, every judgment that is delivered that you read about, even though it comes under the hand of one judge, you can be sure that it has been decided by the panel members. Unless there is a dissenting opinion, it is the opinion of the judges. So that is why we say it's collegial. We go into a college, we call a conclave, and then we come up with decisions. You are right. I come from Gozo. The person who is now the president of the court comes from Navrongo. We have somebody from Owa. I went to the best secondary school in Ghana. Couldn't go to my secondary school. Somebody went to a one of us went to a school which is no longer even in existence. Sir Dennis went to a school which at the time was a mixed school. Now it is a girls' school. Achumamai Secondary School has now become a Fiakobi Girls' Secondary School. So he doesn't even know whether he's an old student or... So...
My Lord, he's still an old student. And the school is still in existence.
And then there is this Wa man who went to school at Koforidia, the town of the flowers. You see, so you are right. We come from different backgrounds, different schools, different philosophies. Some of us, a couple of us, about 3 or 4 of us, started from 2 of us started from the magistracy. Her Ladyship, Avril Lovelace Johnson, started from grade 2. Sergio Jabefe started from the Regional Tribunal. So both below the Circuit Court where I started. And then there were some of us who joined at the Court of Appeal, like Sir Dennis. Justice Puaman joined at the Supreme Court. Justice Yodi Kulendis joined at the Supreme Court. We have persons who have come from the academia, like Professor Mensabus. So we have different philosophies. This is the Supreme Court. And so when you have all these people with different backgrounds having to come together and then agree on something, even with all due respect, you see how lawyers agree or disagree. The little that we saw from the Honorable Deputy Speaker, Honorable Minority Leader, and Honorable Majority Leader, 3 very able lawyers agreeing or disagreeing on the rules, the standing orders. It shows that once we come from different backgrounds, we will have different approaches to things. It could be our strength, but it could be a weakness. As a Chief Justice, your ability to harness all these into something concrete, that is what leadership is about. That is what you should, if you are able to do this, and you should be able to discuss things formally and informally before things escalate. You should be able to do this. Even empaneling can create problems among you when somebody feels that this man is not being empaneled. I wasn't empaneled for close to 1 year, even though I was the number 2 after the Chief Justice. I wasn't empaneled. It can create problems. But as a leader, you should be able to manage all this. And then you should be able to manage all this. And even though I'm talking about collegiality and then the need to have a consensus, that should not be the final thing. You should be able to encourage parties, judges, to air their views. Dissent should be encouraged. It is always better to have a consensus on everything. But if you can't have a consensus, you should be able to, if somebody says, I'm going to write a dissenting opinion, you should be able to write a dissenting opinion. You should be able to encourage the person to write a dissenting opinion. It is a way of fostering unity amongst yourselves. And fortunately, again, having been here for so long and having been here, having dealt with all the members of the Supreme Court bench now, I happen to have personal relationship with every one of them. Every one of them. Those who used to appear before me when I was a High Court judge, like Justice Dorothy Kulendi, Justice Puaman, they used to appear before me when I was a High Court judge. Justice Dennis used to appear before me when I was a Circuit Court judge, and he was a lawyer in Kumasi. And then Justice Ajay Frumpong was a junior to my very, 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 very good friend called O2SL, who has passed on. So when I was even sitting as a High Court judge in Kumasi, he was appearing before me. So I have this relationship with all these judges that makes it easier for me to be able to bring them all together. So I will be able to do that. Thank you.
Thank you, Honorable Hajaladi. You have a further question?
Yes, please, Mr. Chairman.
Please do.
Mr. Chairman, there is a very big issue that is worrying a lot of us when it comes to getting maybe people who are brought before the courts so that the judges can handle them very fast. Cases are not taken up very fast. So because of that, you find our prisons choked with a lot of people, some even just because they have stolen a bunch of banana on remand. You simply can't understand. And if you look at them, when people show you such pictures, it's horrifying. Will you consider ensuring that we have at least these community courts, the tribunals, working very seriously, and you applying the 24-hour economy as you have said earlier on, so that such people can be given community kind of punishment just to deter them, rather than pushing everybody to the prisons. Because recently, just 3 days ago, just 3 days ago, I got a message that someone went to court and then was told that the judge had put to bed, so she was not in court. Now, when is she going to come out, let alone to look at it? And I don't know whether it will be passed on to another judge or that case has to wait. So will you consider ensuring that the tribunals come up basically at all the best places that you can think of, so that such cases would be handled or fast-tracked? Thank you.
Yes, my Lord, your response.
It looks like you are speaking the language of my wife. My wife has maybe engaged you to ask questions about the prison service. This is something that I know about, because as I said, I was a prison officer. And since my wife is also there, I know. For example, I am told that the inmate situation in some prisons was built, the capacity for some prisons is 851. As of today, they are 3,562. A variance of 2,711. Kumasi male prisons was built for 416 persons. As of today, there are 1,727. And this is replicated all over. The prisons are choked. The prisons are choked. Remand prisoners, I mean, it is a bother. And one of the causes of the prisons getting choked is people being remanded, and sometimes indiscriminately. That is why, and then there are also some, as you said, who have committed minor offenses, who shouldn't be there, but they are there. So I think that it was particularly for these minor offenders that the Justice for All program was introduced. And for some time now, maybe because of the turbulence, this year, they have not actually even sat. It is something that I I want to reignite, revamp it, so that we can have the justice for all back on the road, so that we can get rid of some of these persons. But apart from saying this, I also want to say that, Honorable, there are some people in the prisons who have been granted bail, actually. They have been granted bail, but they are still there because they can't meet the bail conditions. And not that the bail conditions are too high. Sometimes they are too high. But in most cases, they are not. In so many cases, they are not. And so you find somebody in prison, somebody on remand, who has been on remand for 5 years, 3 years, 4 years, 5 years, and those of us outside will say, hey, if this man had even pleaded guilty and he had been convicted, he would have spent only 3 years. But because he pleaded not guilty, he's on remand, and his case is not being tried, and he has spent 5 years. But that is not the fault of the judge. If you appear before the judge and you say you are not guilty, you are not guilty. The judge says you are released on bail. But there are some people, unless you say they should sign their own bail bond, they can't get anybody to come and bail them. Unless you release them on their own self-recognizance, they will not get anybody to come and bail them. I mean, there are some of them, and as a judge, we have conditions to grant bail. The main condition a judge looks at is, this man I'm releasing on bail, is he likely to come and stand trial? The person who is making efforts to run away because he has gone to see some foreign embassies to seek asylum, he's trying to run away already. The man has been granted bail once and he didn't appear. And so if a judge decides that, no, a person like that, I'm not going to grant you bail, it doesn't matter the offense that the person has committed. The judge may not grant bail. But even if the judge wants to grant bail, he will not give you bail on self-recognizance. So persons like that, they will not get people to stand surety for them, and they will be there. So while admitting that there are some people who shouldn't be there, there are also some people who are there because they have to be there. And Honorable, we are always talking about a bunch of plantains, a crate of eggs. My mother is a Catholic, was a Catholic. I always tell this story. My mother was a Catholic. And you know, these old ladies, how when they said, in my time, the Catholic priest was a white person. So at the end of the year, my mother wants to go and then harvest a particular plantain that he has nurtured over the year. My mother was going to the farm every morning with a bent back. This young man was sitting under the shady tree. In our place, we call it in Kwankwaниase, playing drafts. Every day, my mother passed by him to go to the farm. Now, 1 year on, it is time for harvest. My mother wants to go and harvest the plantain to come and give to the reverend minister, the white priest, who speaks Latin. And then this young man has gone there. And you know, when they go there, they don't cut the plantain. They move it from the top. So my mother will walk all the way to the place before realizing that the plantain has been harvested. We sit in Accra here. When the magistrate at Gosu decides to send the boy to prison for 3 years, we sit in Accra here and say, the man stole only a bunch of plantains. Do you know what it means to what the bunch of plantain means to my mother. It's like stealing your car. You see? So, I mean, there are so many reasons. The magistrates and the judge, they are trained. They have this, the sentencing guidelines. They have them. But sometimes they have to go beyond it. In my youthful days, I gave somebody 70 years. Atayi, I gave him 70 years. And what I told myself was that if Atayi was given 30 years and he comes back, my family will be the first family he will attack. So by the time he comes back after 70 years, I'll be dead and gone. So you see, then we are thinking about community service. Yes, there are some people who, if you give 3 years, 4 years, touch wood, if I am convicted and sentenced to 4 years in prison at Nsawam, I may not eat prison food for even a day. I will have some people bring food to me. So if you want to make me feel the prison punishment, prison sentence, then maybe you should order me to go and do community service. Maybe around the place where I stole, around the court, that they'll see me, because punishments are not only for the person, the victim, or the person being punished, but to deter other people. So community sentences should be introduced. But that one is in your bosom. It's a law. That one will have to be taken up by you. Another way of decongesting the prisons is through the parole system. People should be able to go out on parole for exhibiting good conduct or whatever. So if the parole system is introduced, I'm certain we can reduce the numbers in the prisons considerably. But, parole system, you cannot do that without tackling the social welfare angle of the parole system. You have to beef up, because I know in some jurisdictions, when a parolee or a person who has been granted paroles may not even be able to go beyond a certain distance because he has a tag that gives AI alarm to somebody. We don't even have these things here. So, Honorable, we are at it. We will play our part by reducing our pension for imprisoning people. We will curb that pension of giving long sentences. I'll talk to my people, because any long sentence person you said to my wife, I get a knock. You allow these people to come here, and they are disturbing me. So, Honorable, that is what we are going to do. Thank you.
Thank you very much. Honorable Ladi, do you have a supplementary question, or you want to ask your last question?
Thank you, Chairman. I want to ask my last question.
Thank you very much. Proceed to ask your last question.
Mr. Nominee, during your presentation, you mentioned places where we can find courts of appeal. Unfortunately, I sat really feeling very bad, because I would say I come from the northern sector. And I have continuously heard my people crying when they have any case that needs to go to the appeal courts. They would have to travel as far as to either Kumasi or Accra. I have listened to you carefully and heard you talk about infrastructure and the way monies have to be spent, which is quite a difficult one. Will you consider putting up at least one with all the amenities that are needed to take care of the 5 regions of the north, to ease problems of our people having to travel these distances.
Yes.
Honorable Chair, Honorable Chair, it is possible, it is feasible. We have done it before. We have done it before. You see, I know how sentimental people feel about such things. When I started acting, I got a letter from a community, and they said they wanted, it was written so beautifully, they wanted a district court. So I gave it to the court's services manager to advise me. And you know what? He came up with the fact that the community they are talking about, they are 500 people. 500 people. And then he mentioned the various courts that are close by. And we found that almost all those courts have cases no more than 10 a day. Sometimes the whole week. It is not, when we tried the Court of Appeal in Tamale, we realized that all the cases could be heard within a matter of 2 months. All the cases. So it is just not feasible having 5 judges stationed at Tamale to take care of the north. This is not just because the number of cases that come from the various regions put together is not up to much. So, to prevent this situation where lawyers and parties will be coming to Kumasi or Accra, that is why we are introducing the virtual, so that they will be meeting in Tamale. The lawyers don't need to, with virtual hearing, the lawyers don't need to move at all. They have to be in Tamale. So, as I said, if you have a case which is being handled by a lawyer from Kumasi, for now, the lawyer will have to travel to Tamale to go and be in the Tamale courtroom where the virtual takes place. But as I said, we are working at it. In a matter of time, we have found ourselves in a situation where some of the parties and the lawyers can be in Tamale courtroom, whilst some other lawyers will be in Kumasi, and they'll be hearing cases. This is done. When international arbitration takes place, people hardly travel from here to London for international arbitration. They do virtual hearing. So that is what, if it becomes necessary for us to station judges permanently in Tamale like we have done in Kumasi, we will do that. But Honorable, you have to help us get accommodation for them.
Thank you, Honorable Adi. You have exhausted your 3 questions. On this note, honorable members, our revered guests, it is in the interest of all of us to take 20 minutes health break. Well, Hajia, you have the floor for 1 second.
Thank you very much, Chairman. So, my brother, I wish you all the best. When my colleagues were leaving, you would have heard them. It's normal of me to say, I wish you all the best.
Thank you.
May the Almighty Allah guide and protect you.
Thank you.
So that you will be able to do your work as expected.
Thank you.
And to the best of your knowledge and to the development and progress of Ghana.
Thank you very much, Honorable.
Have a blessed job ahead of you. Thank you.
Thank you so much.
Thank you very much. We shall resume our seats exactly 10 minutes after 5 o'clock.
Hi, I'm pleased to introduce to you Cancer Mixture, a herbal mixture for arthritic pain. Arthritis,
It's me.
Cancer Mixture, no, Cancer Mixture, no, Cancer Mixture. Yeruba Biara na Nudruo, Morioya, or arthritis. Cancer mixture, obey your juma when you put your inside. I'm a place in the grand. And if you do be a menu on your market for your button, I want one menu for. First, baby, I'm from one and Sanka, saying Susan, Bonibiara, home doctor, and I report to FDA Med Safety App Nodo.
And Katui, FDA, Apinodo.
The National Petroleum Authority hereby cautions persons engaged in illicit storage and trading of petroleum products to comply with the regulatory requirements to operate in the downstream petroleum industry. The NPA Act clearly stipulates that no individual shall engage in any commercial activity related to the importation, exportation, re-exportation, shipment, transportation, processing, refining, storage, distribution, marketing, or sale of petroleum products in the downstream industry without first obtaining a license from the NPA board. Failure to secure the necessary license and properly regularize operations will result in confiscation of petroleum products, prosecution under the law, and decommissioning of facility. For more information, contact the National Petroleum Authority on 0302 550 380. You can also visit our head office located at Jolu off the M1 highway or any of our regional offices.
Na ede na ya obeyi a oda formason ye funum emunumuni.
Oh, Mr. Entry, also yare ya titi be ben fie pi nanso ne yam nyono da se me chew no ahodo amato a me hunu hwe a ebe ya nwanwa.
Menyi ni se what ulcer tamfo hexa capsules any hexa mixture yanum bom kotia ulcer no bia ma no anom anka ne ho ato no dadaada ulcer dro de eno ani hexa capsules any hexa mixture
Ankom ni nchiremu
ulcer ye kura eto ye funu ene ensunumu etuma wo ye funu ekeka wa wogire ho a enyi ulcer etumi ema wo ye cheko ebra wadidi awie so how eye ulcer de a compare hexa capsules any hexa mixture nanum bom na ho ebeto
pedudu etu a ko okanshi drug lane Kumasi Dani Herbal Takradi AA Mensa Anafre 02038228855 Apefo abatanya woma won mofra no fo ene mofra woni mfiedum ye no enka ho Haxa capsules ene ne mixture
ulcer tamfo edie age edwadie nkrato yi atom.
Hi. Now let me tell you about Safari Valley Eco Resort, the first of its kind in West Africa. Upon your arrival, you are introduced to your butler, who plans your itinerary.
We were surrounded by wildlife from the moment we entered the eco park.
So many activities, all in the same premises. Visit the gym or the stables, they have it all. At my break, I'm able to practice my putting.
We also went fishing on a man-made canal. Our tour guides taught us so much about the wildlife and how to interact with them.
They used only electric vehicles here. This creates a serene environment. I'm told it's over 1,000 acres. My cabin here sits on 2 acres with a large terrace space overlooking my private swimming pool. Now this is royalty. They have their own farms, thousands of fruit trees. I can also have my lunch here at the waterfall. Quite a beautiful place you have here.
Visit Safari Valley Eco Resort in Ghana, bringing you closer to nature.
Obrebo eye ejumada. Ebwa eyam eduane. Ebwa eyi insa free ni peduani. Na ebwa woni pedua ma etena ho yie. Nanso wonim say niema a yedi na yenom. Timi ma brebo ye ejumaden sen pote.
Mehunda. Me brebo ye ejuma pa. Ebia se me ntumi ye bibi bo me brebo.
Ani and nothing about the left feet from the Moses Clinic we have our center about herbal food supplement. We see pa de bo brebo ama e ye ejuma ye.
Na ye ejuma.
Fatopa ye no anopa ne enwumre. Na eboa ma obrebo ye ejuma ye sene be ya ebetimi anyam aduane a wodi esiesie ni peduane mu eyi mu finsi ye
eno na me brebo kia pa
Ubenya Live Kid or pharmacy herbal shops ne supermarkets a ebel sa wo pedudo so to a 0244 068447 Live Kid wa wo brebo wa wo ni pedua Edro yi enye ma apemfo ema ema omomanofo ne mmofo a wonya mfie dumie FDA agi dwedie krato yi atum
The serene environment fits into the goal of the school, which is simply to provide excellent educational foundation for your ward's development before they commence primary education. At first glance, clearly you will see why the school is called Hebron Hills International School, as the building stands tall overlooking town. With a Montessori style, we have experienced and dedicated staff and trained teachers. Our small sizes classrooms are meant to enhance teacher-focused approach where children get one-on-one attention from the teacher. Hello there. We are open at 7:30 a.m. and school closes at 2:30 p.m. After school care is from 4 p.m. to 6 p.m. while early drop-off can be arranged at 6 a.m. Hebron Hills International School is located at Midye off the Nsawam Road. Locate us with GP postcode GW0688 GA West and GPS code 06884870. You can contact the school and make further inquiries on 050-876-2375 or call the office directly on 0302-918768. Email us at hebronhills.school@gmail.com. Hebron Hills International School. Excel and shine. Hi, I'm pleased to introduce to you
we are here, Mawakaba, Kasepa, at about TVSYZ, live on Power, 97.9 FM, Inside Politics, Jumedie, Anna Yugoswa, there, so Media and Kelvin Pom. Now, another idea, a vetting committee at Tanase, the nominee for the Chief Justice position, Paul Bafuboni, and they Watanase, Wamrasebe Dream, yet to Tunano, Ebisan in Semahodo. Efa Ghana judicial system no ho nia wode ba nia wonim ni obetimi dia ba beka ho na ma yen judicial system no etimi afa na ntima pa bi de efra enti wo mra se bedwam ene ho ayebutubutu ba already minority stage workout at a free horn one me no ka say nkoma hodo a ekoso a wo mo twetwe e wo mra se bedwam say benya chief justice no wababedi emra anim. My Ghana said the Bibiabeko Yeno. The MPP minority led by Afenyo Makin. Oma Peja Mumu. Into Amon Kahon. Now, and come across social media and other platforms. One must say, one must share the way Afenyo Makin, Esha Sia, na komotwetwe kura yi no yente Chief Justice nominee na no kura no asem na so afenyo mark hyase so attack no wo mumu de social media no so mahunu say afenyo marking ene MPP for no ma bom tirimu pose kwan bia so enya de omo betimi atena se da ama veti na ko na wiye won bom modin asori akọ efisa afenyo marking edikan aka on the floor of parliament say na nya de a even veti ne kra be koso na so amane sa ama veti ene de me ne wode kan yabusia eguso koso a ye hwe sa akamre kakra bi wo mo dane omo aba na question saka ye beto edi ama the Chief Justice nominee Paul Bafuboni wano so timidi na no yisem edi eguso se beye na se de ye nyina ye hwehwe se judicial system no se wo ma wasem so na wo de court a se nyese bia ukuta sika bebre ana se nyese bia wo connection na contact na mo perepere yo eni da so arehemu ai minim se me enke obrempon meni obi biara nya asem na se medi bi mo ame kokot wa medi bi mampa anye se nipa no so owo ni sika bidi oye famous esneme etino sa asem ne yakwa ye be koa me nsa ne age di ama no se de mmiri bi atwam no nsem bi ekokọ so wa ha ye nyina ye hunu ye another MPP the minister and national security minister Kandapa one part of the MPP. Wow. Maki kan sembe be say judicial and some ekoso emwa. Etiabusia hi TV XYZ live on Power 97.9 FM your social media Facebook TV XYZ Power at Power 979 FM YouTube XYZ broadcasting inside politics jumedi and ye guso ide somono. Mami kanfo gentle step madake FM ene enyumre anasa wiye yabusia gentle step madake eniema hodo a obeto wabreko a wo pese won dress wo mane yie wonya niema pa amofra ne di betimi di adi agro no eye gentle step madake na do ani bejo omo dresses for children both boys and girls amofra ntade so ye be ma so ye oba me ba cho gentle step be ma bi omo baby dresses motor for kra wo ntade on be ma bi afa bicycles and tricycles amofra di agro wo fie me ye ni ko omo bi baby cot omo car seats baby walkers high chairs baby bouncers and swings, baby diapers, breast pumps, baby food, and mofra won ye maybe a washer ediato. Maybe a gentle step madake, and I make for the amo and you may say do any better. Wukwa, one more nina na papa, Nelson Nibo, Edda from one, Sikaka Krebi Kitano, Ubetimi and Yabiato. Come shop no, I was Sprinters Road no so, a bank Pogas Furniture opposite Absa Bank. Na fe. Prices are a da from Nelson Yama pa on sentimi kokabi. Now, man wa woman, one so many intimate. But what me ehunu Facebook, gentlestepmothercare.ghana. Now ko Instagram there, gentlestepmothercare.spintex. But more than enough for number we na frewom. Na fe, ni a wo hwehwe dia ma wo mano. So your ba so ye bema. Na ne nia timi age, eye ntadiem. Anasa niema amofra de bedi agromo mani agye no gentle step marake na onfa bi enfendomo number betimi from also 0244 238 477 0244 238 477 and 0245 681 085 0245 681 085 na fe gentle step marake wamo emboa miwia na me de ko Benji Estate and Investment Limited ebusia Abibia meka say we ase ade ba ko ma sumdue pa ni say watimi ase ufie de awie enemre mu de Benji Estate and Investment Limited ana ema sada yeso ni nyina bem because ensase a ne buofo na mansu bia ne ho ne ye ho nkrata de ama ofree eno ana Benji Estate and Investment Limited e ka kire wo enti bomode na fo ani kire Tripoli New Airport City Shai Osudoku Afienya and after a year Central University near B5 Company, Sasi wa nibu a year for 4 Benji Estate and Investment Limited. About more than that, one metimiyama will be at 70 by 100. No waje one plot. So would this school? So this year sorry that Jumedie be our person would be a Benji Estate and Investment Limited. And I make count for the amount. So ubebo more than wako. No more jebre. Ama wasase pa. A nebo edda from one ubetimi de ujumadi a na benji se anka jo say affordable lands no enso ha na mom de omo ye ne etie me na afa hye ne nso omo water and electricity available was asase nyina so asase bi obekwa koto electricity nu ho kwan ko obefa so nya nsuo kura edin benji se wo boa sabre de nsuo and electricity uni problem won sa asene so afa wo mo ma anwea free a obetimi de ahye wo dan sinase umpewe na opedade bobode na yire ho na kɔ benji eye estate and investment limited na afi wo momoden no mo hwew memini da bia o mo say ye free site visitation memini da bia nti ukwa asase ne ba bia da ope ne buofo fa kakra bi fa hye ho udu ya no registration no deposit sa asase ne ye de obakɔ kire no opede a ye wo de a na afi wa hyase eye project ne wani age de de wo mpra ne say document asase na obeto no Benji Estate and Investment Limited so mo ye de acho free untwa wan Ghana city crown ho ti bomo ne to mirika na wo wi a building construction wo man ka so mo ye bi afi aye barter trade wo mo ye se wo bibi na wo de sesa bibi wo man ready Benji so mo beje no ma ye de amount land survey land title registration supply of building materials ni nyina ye juma Benji aye Estate and Investment Limited wo ma bomo de ye na afi wo mo de aboa wo man Ghana nyina obehu wo ma kira kwan e wo tema community 25 junction opposite Goodness Filling Station numbers abetimi anya Benji Estate and Investment Limited na me to dwa no bomo de na fa phone na afi je na enani wo kire ya de kire na won so santimi nka wasase 0248 780 887 0248 780 887 and 0553 116 602 0553 116602 na fe Benji Estate and Investment Limited wamuntimi enye wadom emma wasase abetimi de asi ufie u school hospital u market jumedie bi apese odidi na bibia anye kamama okọ social media platform no so a eye Benji Estate ana obehu omo ho ana some website www.benjiestate.com na ho so watimi ni omodi ehon kita ho Benji Estate as you follow your vision and own a property today. I was here, Mensaka. A Kwanya Power FM. Efaso. Na ya chefo, ya tiefo, abribia, ya nemudi jumano, ya timi bomode nesika kakra, etimi brabedi mu botom. Etanyumre se utie mi a, bomode na fa phone, me bobo na wudi akire, me bobo so na wudi akire. Ansama manu besi, Mensaka phone so wadi ska. Eti aye simple, bomode na fa phone, na dial star 274 hash. Star 274 hash. Star 274 hash. Na sane. Me pacho follow options no. Choose Power FM. Na di achire. Ukuta 5 Ghana city. Utimi to be. Na ubetimi wini up to a team of 50,000 Ghana city. Titisikano 500 million. Na fe onsu watimi di size cano be. Area go bottom abribia. Other amazing prices and so on. Utubia. Star 274 hash. Unya bope me bacho ayesika na abegu phone so we nya fe ne yekoye se ya na sese dabi ubedibi na fe wani atimi age kai na hye nso sa Mensaka aye Power FM ede abai eno ana ye first NLA Caritas platform no wo magye atum se ekwampam so no abasa meboa Ghana fo no omunye sika aninwo mu botom na emom uyo bi a wundi mfie du wotwe a me ba jumadi e won ka ho ensihye kakra so ebata ho nti Mensaka Power FM aye de aba no sika no ubedi bi e star 274 hash bonus si a na fe choose Power FM na to aso 5 Ghana city 10 Ghana city 50 20 de obetimi bi ato ebeda no sika ere ama ho na enne mutie me yie pa ade ba ko abiribia wo bia ba o program wa ofiri ho ne wura mfida eye one aduane nsuo anansa eti ye ba program obo se ye check akra ekomode yen ensukomode yen mo ma drink bia enwumre we ma menkanfo nsuo pe a obetimi de adi ujuma bia ebeye asem ada wo mu aba ujumadi ni bi de akọ na abiri o ma ba odimpa eye X natural mineral water enuane nuo bia ensuo ehia de ama nipadua X natural mineral water ewobi eti jumadi bia wudi sa wo ye party sa wo ye ye sa wo ye birthday sa wo ye engagement sa wo ye wedding eye X natural mineral water ana wasa won setimika na wo de serve adofo na afi ani die timi ba yie pa ukom melcom ubenya bi ato baby biara shops akese enketwa a wo mo ton nsuo eye papa no me ba chew eye X natural mineral water ana ba koto ho na afi watimi atobi tobi fa gufie woni abusuafo ne nom na afi enuane nuro ana nupa e wo nsuo mu a e wo se abusuan ni nyina timi dibie ana omo num bi na omo to omo no wonso wonsan timi nka bi friend number si na se bia wo pe X natural mineral water ne do so puo watu akwakoton na wonso wanya faso de agu boto mu a di eche na wonsan timi nka bi 0596 273 546 0596 273 546 and 0596 273 547 0596 273 547 X natural mineral water. So simply natural. Na bibi biara aye kama. Mega cash lucky box and so about where boxes. The obe to be a scar woman. And that's why XYZ and a day ba. And you know, I had no idea. So what you now say? I believe yes, you want to say so. What you are daddy? Now they share TV XYZ. Would you hear Power FM, Radio XYZ? You fuck when you so near reward back. And see Mega Cash Lucky Box XYZ. And so the other and also your simple. But more than for phone. A star 426 star 5 hash. Star 426 star 5 hash. Now if I who them. But more than that to. Wotimi to be 10 times so kura no a wotimi nya ebe the point I no timi ma kwan live draw Mondays our exports so me ba chaw ubenwu se wodi aba betodwa what is cap 10,000 Ghana cedis branded t-shirt your caps afa weekly giveaways just say eniema pa ewo mu no wodi ska na wodi t-shirt na wodi caps na wodi niema betimi ama wankasa no wani atimi agenti opportunity ni nie dial star 426 star 5 hash star 426 star 5 hash network be a kitawo now betimi ediska ubetimi edit branded t-shirt branded cap any exciting giveaways now what we be aremu mega cash lucky box XYZ the abano wonso wetimi anye says can be such media so NLA Caritas platform no wagiatum na wonni fie do wotwe still na no me ba cha won ka ho enhyehyɛ kakra ebata ho fa ho ka ho na fa timi di sika kese wo XYZ Mega Cash Lucky Box no another product from Spark House Promotion and the Super Cash Games anchor for a disika wo mo ho dede abusia ya to adwumadi no so aha power 97.9 FM live on TV XYZ live on Facebook at Power 979 FM and afi TV SYZ and also ewo Facebook SYZ Broadcasting ewo YouTube na fe bomode na dwumadi ayedi ni nyina no wonso timi fa ho ka ho na tie bi sika ye che enema pa ye che wa ha no ene ensem no sede e ba ye de emu kire papa krogyen de ba na ye yin bi mfrimfa bi nka ho no wonso bomode na fa sa akonya no so bi na ehunu midin ade ye nke obrempon ne me na me ti dwumadi so enyimre sabre de ye nko doctor ho yankwa doctor ho yapomudin Dr. Mponsa yapomudin enema yebeye na beboa yen going forward ni yebenya hoden da biara de aye adwuma yenya sika ade agu yebotom Dr. Mponsa ewa apomudin wonsem bebre a waboboa no menchim mfiri ho wode ewom yenhwe Dr. Mponsa mra yenso adwuma de ne so
midin de Dr. Mponsa me ka jesoma me se wayare safi Dr. Mponsa eye wayaresa fi efise me ba na ayaresa aba enunti ene program no mestre se kache unua se onfa na fidie no frɛ no phone so se onfa na fidie no nto TV XYZ onfa na fidie no nto ho na onfa ne radio no so nto Power FM eno so obete menka se Dr. Mponsa me ba na kire se yare no dwane otimi din no dwane because onim se anya bia magic machine e wo ho ana asai ensai da ne santi yare timi din ana o toto folesim ukọ ho kura mechesi wa besa yare no because mani abre ai ye ja na ati ase abeteta asen aba enunti mani abre se ayaresa no se de mi chesi yare na nkasa ha ne santi ene me pesa me ka bibi kire wo a wotifi a wo yare hwe me na follow me me TikTok no ye Dr. Amponsa TV simple kra ena YouTube no so ye Dr. Amponsa TV sa na tie eti every bi a pesa ukɔhwɛ video so no kakra na uhunu se doctor ebetumi abo a oba onsa ebekan ena ukɔ internet so ope Uber anase yango ede aba eno an se obebo Dr. Amponsa Herbal Hospital obo ya car no do beba Dr. Amponsa ene ne medican aka ho asem eye yare a achi enkrofu a wo mu nim yare kro yo enkrofu bebre da fie o yare pa nanso o se doctor minim yare kro a ha me tie me ya wa yare bi te se wabubu agu fom nanso onim kra se eye stroke bebre tumu ka o se o yare stroke o se da bi o doctor se me yare stroke nanso o te fom eye bubu yare no bi ya onkrofo bi wo ha omuntumu nkasa enso doctor se on stroke enu nso ewo ho ya onkrofo bi wo ha ombubu ngui otumu nante nanso ni sisi achia ya wo yare hodo a eye saa ya onkrofo bi wo ha ne honam hyehye no te se ja nanso onim yare kura ama ne ho hyehye no no na dwe da ni timo ane se ya tomi aduro obi na eye mi aduro minu ya wo hwa me na enya aduto yare no bi wo ho ane ya aye no no ebeba na abejaw burning sensation a wo hyehye unim se stroke yare tumuma oni padua mu hyehye wo pa bebre nim sa de we se stroke bi wo ho a ebechewo a ema sa burning sensation we but eno no more no afa o half bonsa wo side ha no nyina ehyehyew pa o heat no doso what is hwe na brantem na stroke wanchew obi so ho a burning sensation na eye no no bibi wo yam ya friend ga brother sa brother ya meka ho asemi elikia eye acid sa acid no kwa wo sesemu a o ba hyehye te sade ya ofiefuo anase obi ahyeda ede maku asrawo minua bra Dr. Amponsa me de machine magic machine si uso a ebe collect cells na anya problem no nyina na amasa hyehye no nyina ajai na ya ma okradru because a prepraw obi wo ho a ne de ne ye Johnson no a ewo se ekọ ne brother nom na o Johnson no kidney na fail no eno ti sa amasa acid na enye na ewo se o Johnson no akọ ne nipadua nom minu a wo hwe me ne o sa nipa no bomode na bra ye the magic machine si usu a ebejai na ya ma o ekradru na ho atọ obi tie me ne wo se doctor me de ne de me kidney no yesi eye pa nanso me hu burning sensation no ora fi se Johnson de wa wonyonso hwe nyame bo nipa no se toilet no ana se nuane ne ya adwuma wi a ewo se uyi tugu na uye free but oba titro man tumu kipu Johnson obetumi kipu Johnson sa bi afra no patu anwumre ose me ye wo ya wie na Johnson no asenya yira ekọ he asenya reverse koye adwuma foforo enti acid abawo nipaduanom ebema burning sensation ese prepraw emana mu kodwom toilet ya de wo se me kwa ba nsa na makọ toilet wo be ba na toilet na yira ekọ he senya koye adwuma ma toxic efi akọ wo sister no mu nyina enti sa wo hwame a ade ama wo bre obi wa senti age ni nipadua mu nyina hwese de toilet de etie na abase koyi metugu na wo se dabi mekipu na asenya ko nipadua nom ebeja sent be more problem ahanko na abenya we yatie o enkrofo amoyare diabetes tifie amobre diabetes asichire yare muntie miye pa bebre wo ha na adwen so makoto aduro e friend diabetes aduro entum nsa yare no da me kire no kwasem no Adeɛ tumo ma wo diabetes ya ekodo ɛyɛ simple. Bibi wo nipa duanom yɛ fra no pancreas. Pancreas ne dade wasi kyerɛ nyina yɛ adwuma ma wo. Wanya ulcer anase kuro aba wo yam ama ulcer no afro pancreas no. Ɛno nti pancreas ne yare. So pancreas ne yare a ase kyerɛ no bɛfa mmɔgyam. Ɛgye wa ba Dr. Amponsa Herbal Hospital. Na ya koleto pancreas no. Tiemiye pa. Yaba koleto pancreas no. Se pancreas no ho tono a ase kyerɛ akɔ mmɔgyam no. Obetwe ni nyina. One diabetes biem. Saa na tie. Ɛno ti diabetes na wanu maduru enkoda no. Saa na tie. Bramaso ya na memwa wo. Ya was Spintex Coastal Junction. Uduru a taxi station na ewo ho no. Buso omo se o hwe Dr. Amponsa. On bechero o de Uber nso abo Dr. Amponsa Herbal Hospital. Edobeba Street. Edi se wo tie me ne ana se wo hwe me ne na se wo yare asikyire yare a bra na ye koleto pancreas na wo nyare asikyire yare biem. Obi so say doctor me yare diabetes no enya no na meso ate se say me nan so nyina asate eye kuro saa dete yare no de ekreti acid more ese wo hunsuo no mogya no tie me ye diabetes nya HIV yonko no no se de amanfo suro HIV amansuro diabetes no enya HIV yonko no no yare to be just 12 hours e phone nipa when say HIV de a friend say 2 weeks cra phone nipa da HIV the years and a be phone but diabetes the hours any minutes and a year na juma and untinya HIV yonko ne diabetes it is a can't ye na se wutie me na se diabetes a start was chire na start kosoro na wankasa ojonso ntentem a se wo mfili okay o ho hyehyew anasa o ho ye obasa eto de ye o se obewu ade be chena ate wa saa diabetes no eno nso ebo okoko se bra ne ye nhwe se ye bi ye ntu ase ma wo obi tie me na wase doctor na me sanso wo BP o diabetes no wo fase ye ne BP eti se wunya diabetes ya de tibia obenya no wo fase ye no anase ne ba diabetes no wunya ese wo nipadua no neyama no ema wakoma ho oden kofom e kire onne obirebo no na ho oden kofom ukid na ho oden kofom ulance no na ho oden kofom ana intestines no na ho oden ekofom eti ese wo nipadua no neyama ewom no na anyaw prosoro aba esophagus no ebetumi na halitosis enti kwan aba we no ho enti digestive no a aduano no se wo ho no scent no bi fa we no ho ba esophagus no oba ye beboa wo ne ya sa oyare ye okrofo bebre ho mo hia awo maso ye ya de ketewa bi wo hia twins kra won sa beka ebe ya ma wo obi so wo se doctor me de me wa typhoid fever typhoid no yare ben etoda uti paa ho na okon agene wachi kasa ye wo ya omfe ewo wo yam abubom wani so chiri ho ye obasa ye wo se obewu adebeche na ate ho 0243 we WhatsApp esan ye calling ofre adansa o ye voice message ma me WhatsApp wa me pepa 0243 110875 0243 110875.
Go to court. And so we want to, as we want to build courts to take care of the more cases that are coming up, that we also want to encourage ADR. I was at the ADR week in Koforedia, and the report that they give us that of about 600 cases that came, about 470 or about 480 they were able to solve them through ADR. And so we realized that if but it is still not, people still do not know so much about the ADR. So if people are sensitized enough about ADR, they will embrace it and then leave the courts for more serious matters. The way it is that there are some people who, no matter what, who want to go to the regular courts. They want to have their pound of flesh. But so it's a combination of a lot of things that lead to this backlog of cases, and that is what people's confidence or trust in the judiciary going down is more as a result of the fact that their cases are not heard early. There are some people who also have lost confidence in the judiciary because they say that judiciary is corrupt. How they come by that decision, that statement that judiciary is corrupt, I have made mention of the fact that the judiciary is as corrupt as the people who man it, and the people who man it are as corrupt as the ordinary Ghanaian. The ordinary Ghanaian goes to the bank and he is told that give your money to the teller, otherwise you may have your money stolen. He goes, and instead of being in a queue for just 2 minutes, he sees somebody sitting down there, or somebody recognizes him and says, "Oh, I'm a teller," and then he takes his money to go and deposit for him. Before he's aware, the man has stolen his money. The ordinary Ghanaian goes to the courts, and I tell you, if 100 people evince the intention that they are going to see a judge because they have a case in the court, less than 3 of them will be able to go to the judge personally. They will go through his girlfriend, they will go through his wife, they will go through his friend, they will go through all kinds of people. So anybody who they think is close to the judge is game. You go and give your money to a court clerk or anybody. There are some people actually loitering around the courts who the court clerks, they know them. We have people we call bail contractors. All kinds of people patrol the courts. So you want to see why you want to see a judge because you have a case there, only you know. And then you cannot go and see the judge because you are afraid. Then somebody tells you, "Oh, that I saw the judge talking to that lady. So it is his sister, it is his daughter, it is his girlfriend. So go and see her." So people give their monies to people, and then they don't, once they have given the money out, they have bribed the judge. They have given, they are okay. So such people go about saying that, "Oh, the judges have taken their money." And once the judge has taken their money and they get their judgment, they are okay. But the judge has taken their money, they lose their case, and then that's when they start talking. So that is not to say that there are no bad nuts among us. There are. But these are the reasons why people's confidence in the judiciary is sinking. And I intend to, once we know the causes of the decline then we can tackle it. So if we sensitize people about ADR, that there's not every case that should go to court, mainstream court, and we sensitize people about ADR, people will go there, the backlog will reduce. If we review the rules, as I suggested earlier, it will affect even the trajectory and the speed at which cases are heard, and it will improve. And if, as I said, since there are still some bad notes, if we catch the bad notes and they are disciplined, then it will serve as a deterrent to people, to other judges. So we are going to, as it were, reinforce the disciplinary measures. The Judicial Council is going to take up this up because we already have a complaint unit, but people don't even complain there any longer because sometimes they feel that they have complained and they don't get good responses. I'm going to reignite the whole thing, reinforce it, so that, because we should get, the judiciary should be able to get the confidence of the people back. Otherwise, we might end up having people saying that, well, I'm not going to court, I'm going to do what they call mob injustice. Thank you.
Any further question?
Thank you. Having listened to you, I want to find out, will you reinstate the electronic case assignment, which was introduced to keep judge shopping and later discontinued by your predecessor?
I think I am all for it. I am all for it. It is going to be reintroduced. I think about 2 or 3 years, for about 2 or 3 years now, we have a situation where applications that are filed do not have return dates. You go there, they say date to be fixed. Immediately so we found there were situations where a case comes before us, an application, even before the Supreme Court, an application comes before the Supreme Court, and we realize it is virtually moot because the application, which was actually time-bound, had date to be fixed on it, and it has been fixed for the past. So immediately I came, I said that one was wrong. So every case that is filed, every application that is filed should be brought to my attention so that we fix, because most applications are time-bound. And so I did that for some time. And now things have stabilized. So we don't have dates to be fixed again. We now have dates given to applications that are fixed for hearing. So with substantive cases, we are going to reintroduce it used to be there until the machines broke down, the system went off, and then it was allowed to fall into abeyance. Now we have actually started doing the electronic.
Thank you very much, Honorable Umar. Do you want to ask your last question? Yes, please do.
Thank you, Chairman. Would you recommend to make the appointment process more transparent?
I think I'm the wrongest person to ask this question because, as I said, I have had my elevations across political divides. But I think the current system is going to be amended. Then that's it. But the current system with Superior Court judges up to Court of Appeal, they are appointed by the Judicial Council, by the President, in consultation the police, the army. These are all members who come from different backgrounds, and they have contribution appeal. So, and when it comes for the president to appoint, we have the idea is that the bench, our performance is also always reviewed by so we have a situation where when these three lists are produced, you find a particular, let's say we want an appointment to the High Court. List of the Chief Justice, in the list of the bar, and in the list of the Attorney General, because the bar is the beneficiary of the efforts of the judges. So the judges make recommendations. In the same way, when lawyers appear before us, we know those who are good and those who are bad. And we also know those who have the temper. And I'll tell you, I can tell you that you will be a good material. So apply to join the bench. So even though the Chief Justice could also nominate somebody from the bar. So when these nominations...
217. Round members, subject matter committee members can ask 3 questions, but they are only entitled to 2 supplementary, if any. So, Honorable Bede Asidin, you have the floor. The name is Bede Sidi.
Thank you very much, Mr. Chair. I was going to correct it because you are putting the wrong name to go into the Hansard, and I object to that. Anyway, thank you very much for the opportunity. My Lord, congratulations for this nomination. And I think that you deserve this nomination. You have served this country for such a long time, and I believe that what is happening today is the icing of the cake. And
thank you very much.
We will proceed to ensure that you enjoy this cake. Let me also use the opportunity to thank you for the guidance that you provided me whilst I was in practice. I appeared before you a couple of times, and I think that I was impressed with the way and manner you guided me throughout. I didn't stay there for long and came back to my political field. But I appreciate what I got. Thank you very much, my Lord. My Lord, I have a few questions, and I will send you back to the issue of the appointment of judges to the bench. And as we have already stated, this has been provided for under Article 44 of the Constitution. And that provision gives the President the power to nominate and appoint justices of the High Court, Court of Appeal, Supreme Court. Yes, there are certain processes that go through, but ultimately, it is the President that we see. That's what the Constitution has provided for. He does the nomination and he does the appointment. As part of all that. You have tried to explain that even though
Honorable, you are violating our rules. Please ask question.
I'm asking the question. I'm laying the my mic is. My Lord, I want to find out from you. Do you agree with the current arrangement in terms of the appointment of judges to the High Court, Court of Appeal, the Supreme Court, the current arrangement as provided under the Constitution? Or do you think that we can have some other arrangement? And if we can have some other arrangement, what type of arrangement should it be? Thank you, my Lord.
I do. You asked me whether I think the current arrangement is okay or it should be adjusted. I think that the current arrangement in football, we say if it isn't broken, you fix it only when it's broken. The current arrangement has served us well from 1992 till now. It's not broken. You shouldn't fix it. I believe that the current arrangement, see, the Constitution, as we have always said, must be read in such a way. You should read every phrase and every sentence, every word in the Constitution. And then, if you look at the practice, as I said, as you rightly said, the nomination and appointment and everything is done by the president. But I have told you what goes on in reality. And in reality, the Judicial Council plays a very crucial role. We advise, the Attorney General has a role to play, the Bar Association has a role to play. And so you may not have this laid down in the Constitution, but in practice, this is what goes on. And that's why I'm saying that, as far as I'm concerned, I'm comfortable with the current arrangement of appointing judges. And that is how I see it.
Thank you. Before allowing you to proceed with your second question, I want to remind all of us about Standing Order 88.7, and I read, a member in asking a question shall not address the House, raise any argument, or offer an opinion. So let's keep to these rules and then we can make progress. Now, your second question, if any.
Mr. Chairman, I have a supplementary question.
Yes.
My Lord, my supplementary question is that, having heard you, and you are convinced about your position, how do we remove the suspicion or allegation that some presidents try to pack the course? How do we remove that one? Even though people go through all these processes, and yet the allegation is that
you are violating the rules that I've just read. So please, my Lord, your answer to the supplementary question.
People suspect that in the first place, what is packing the courts? Are we talking about the number of persons appointed to the court or what? Yes. I don't know how people's suspicions can be dealt with, but as far as I'm concerned, as I said, persons have been promoted on the advice of the Judicial Council, if 40 people, names of the current list, on the advice of the Judicial Council, 41 persons' names were sent to the presidency, and only 4 out of the 41 names were taken out, and even only on the grounds that they had not finished with the background check, as at the time they were because I was sitting on the, I was pleading with the president that we needed to have these people sworn in so that the legal year could begin with the courts full. But the president, they had not finished with the national security clearance for all of them. In the long run, out of 41 recommended by the Judicial Council, made up of members of the bar, members of the judiciary, members of the Attorney General's representative, these 37 out of 41 names were sent to the presidency, and only 4 were not taken. If anybody sits outside and says that the president has packed the court, how will I be able to convince such a person that it's not the president actually who put the 37 people there? We did. He only took our advice. So it is not as if people's suspicions are going about that. You cannot go about trying to assuage people. You can't do that. People will still have their suspicions. One of the questions that I got was, people are saying I got my nomination as a result of 2013. I have explained my way. If people still have that feeling, can I do anything about it?
Thank you very much. Yes, any further questions?
Yes, Mr. Chairman. My second question, my Lord, you have dealt with it partly, but I'm bringing you another angle. Under Article 154 of the Constitution, 1541, you if we approve you, which we are going to do, you will become the chairman, because I'll vote for it. You become the chairman of the Judicial Council. And under Article 154, you are enjoined as a council.
What is your question?
I'm bringing the question, Mr. Chairman.
Please ask question. I've just read the rules to you. You can address us.
Very well. Simply, what reforms are you going to bring to the table outside the reforms that you have already mentioned? Because you have already indicated some reforms that you are going to do. What other specific reforms are you going to bring to the table in terms of accountability, professionalism, etc., etc.? Thank you.
The Judicial Service mandate is to adjudicate cases and then ensure that the laws, the Supreme Court will interpret the laws, and all these come as a result of adjudication. As I said earlier, and we all agree that one of the problems that we are having now, the crisis, is as a result of people losing confidence in the judiciary. And we have traced it to certain happenings. Like, as I said, we mentioned the complexities of the rules. We talked about backlog of cases and all that. One of the things that that is there, but it is not really nationwide, is the e-justice system. The e-justice has been introduced. It's been going on for some time now, but it looks like the e-justice, which is supposed to help us in so many ways, is only within Accra, and also even within Accra, it is within the law court complex. It is my hope and ambition that we will have a rollout of the e-justice to all the regional capitals by the time that my term is out, by the end of next year, all the regional capitals. The aim is to get e-filing, e-justice to all courts in the country. But that is a long-term thing. My aim is to have the e-justice rolled out in all the regional capitals. And that will be something that will help. And then we always talk about justice in terms of cases that come to the court. We don't talk about justice in relation to even the workers. It is very, very, very important to recognize that apart from the judges, the judicial system is not made up of only superior court judges. Superior court judges, by virtue of Article 71, have their salaries decided by the presidency through the committee and then parliament. Whilst the lower bench have their salaries tied to normal civil servants. And worst of all, the judicial, who actually form the bulk of the judicial service. As a matter of fact, if you look at our numbers, the judiciary made up from magistrates to the Chief Justice, we are just about 511. Only 511. Out of that number, those who form the higher echelons, who enjoy Article 70, Article 71, are the High Court of Appeal and the Supreme Court. We are not known more than 230 or something like that. So if you talk about our salaries in terms of Article 71, you are talking about only a fraction of members of the judicial service. So we also have to think about reforms that should affect the lower bench in terms of salary, in terms of working conditions. Because whilst we strive to get accommodation for judges of the Court of Appeal and the Supreme Court, even some of the High Court judges, even in some regions, regional capitals, they don't have accommodation. As for the magistrates and the circuit courts, the least said about them, the better. Because you go to some places and they are renting the most beautiful house. And before you are aware, that most beautiful house belongs to a perennial litigant, perpetual litigant. Somebody is almost always in your court. So you find it impossible to even work. You understand? So we should also be thinking about, whilst we are thinking about clearing the backlog, doing that, we should be thinking also about the staff. And that is what I mean to do, I want to have a proper discussion of the terms and conditions of the terms of engagement of the lower bench and the staff. That is something that I will make my personal project.
Thank you very much. Yes. Any more questions?
That will be all for now. Thank you very much.
Well, thank you. You said that will be all for now. I believe you won't have the opportunity to ask questions again. We are now moving to the leadership. And I'll plead with the leadership that the 3 questions rule would apply to us as well. So, Honorable Majority Leader Mama Yariga, you have the floor.
Thank you very much. Let me also congratulate the nominee, Acting Chief Justice, for his nomination to occupy the position substantively. I'm sure you sat through and you listened to the engagements between myself and the minority side. I had no intention of preventing anyone from freely expressing themselves. I just wanted them to do so in accordance with our rules so that there can be sanity in the way that we conduct business. I think the gravamen of their case, which I would have preferred that they sat here and asked you, because I know you are very capable of providing them with a response, is that they question whether it is proper for you to be taken through the vetting process because there are a number of suits pending challenging the removal of the previous Chief Justice. They're asking what the implications for stability in the judiciary will be, assuming that those challenging the propriety of the removal of the previous Chief Justice succeed in their claim. What will be the nature of the enforcement of the reliefs that they are seeking, and etc. So basically, the question is, do you think that it is proper for us to go through this process whilst these suits are pending?
Thank you, Honorable Chair. I think it is proper. That is the first basic answer. It is very proper. It is a constitutional duty that Parliament is performing. And as at now, there is no order from any court of competent jurisdiction stopping you from performing your constitutional duty. The President has nominated somebody for Parliament to vet the person for the appointment to the position of a Chief Justice. Vetting of the nominee is a constitutional duty imposed by you by the Constitution. It's a duty imposed on you by the Constitution. So if you have to perform it, nothing, and I think absolutely nothing, stops you from performing your constitutional duty. You see, in the years gone by, when cases like Dufour versus the Bank of Ghana, which I authored, actually, were written, the learning was that, and the practice actually was that when an application for injunction or when there's an application for injunction is pending, then you hold your hands. So there were situations where persons will rush to court to file a writ or file an application for injunction, and if you go against, even without any order from the court, you went ahead to do what the injunction was being sought for, then you'll be cited for contempt. And cases like Dufo versus Bank of Ghana, Sito and other things came up and said that that was right. That was it. But the learning now, particularly after the case of Vincent Assefuwa versus the Attorney General, I mean, it's an unreported case. It was done fairly recently. The learning now is that if there is a constitutional duty to be performed, until and unless there is an order from a court of competent jurisdiction, no constitutional body is prevented from performing such a duty just because somebody has filed an application for injunction or even a writ. Even the application for injunction may be handled, may be understood, but a writ, when we do not even know when the writ is going to be heard and determined, you can't do that. As a matter of fact, that is constitutional. But let us even look at an analogy. When President Kufuor was declared, President Mahama was declared, and he was sworn in on the 7th of January 2013, it never prevented His Excellency Nana Kufuor from pursuing the petition. He did. It also didn't prevent the president from performing his constitutional duty as a president. He did. These two things went side by side until the 29th of August, when the court said the matter was ended in favor of the sitting president, so he should continue. And he did continue. If the courts had come to the conclusion that it was, the judgment should go the other way, and that the president should step down for Nana Addo Dankwa to take the seat, that would have been the order of the Supreme Court, and would have been enforced by Article 1 and 2. The same thing would have happened in 2020 when there was this petition. So a constitutional duty that is supposed to be performed, as a matter of fact, some persons are even of the view that even the Supreme Court cannot even come to the parliament and then make an order to stop a constitutional duty being performed. But that is another matter altogether. But for as long as no order has been made by any court, a constitutional duty will have to can be performed. And I think it is right that we are going ahead with the vetting.
So in essence, there's no court order restraining the president from nominating a Chief Justice? There's no court order restraining Parliament from processing the nomination of the president?
There's no court order.
And you are here because we have summoned you to come for us to process you?
Which I couldn't refuse to.
Of course you cannot refuse our summons. you cannot refuse our summons. But the second issue that they raise, and I want to be fair to the records, is that they also say the cases that have been filed, you are sitting now as the acting Chief Justice, and that you haven't listed those cases to be heard. Is that accurate? And why would that be the case?
If this statement is made by, with all due respect, I don't know whether it is parliamentary language.
Yeah, they made it here.
If this statement is made by a person who is not a lawyer, I will put it down to ignorance. I will say that maybe the person is uninformed about legalities, so I will pardon. But if a lawyer makes a statement like this, I would think that it is populist and maybe downright mischievous. The Chief Justice does not list cases, and please, my words, the Chief Justice does not list cases for hearing. The Chief Justice empanel judges to sit on cases that have been listed. Cases are listed when they are ripe for hearing. So we have listing, we have cases getting ripe for hearing, and then being listed before the empaneling is done. The Chief Justice comes in after a case is ripe for hearing and it has been listed, and then he empanels. So the Chief Justice cannot be accused of failing to list cases or empanel, when the case is not even ripe for hearing. A case is ripe for hearing when pleadings have closed. Pleadings get closed with it. Pleadings are issuance of a writ, a response, and then even sometimes we ask you to file memorandum of issues, particularly constitutional cases. So these three things are done, and when they are done, we say the case is ripe for hearing. Then the registrar will list the case, list all the cases that are ripe for hearing, and the Chief Justice will then empanel judges to sit on them. So if it has not been brought to the attention of the Chief Justice that these cases are ripe for hearing, or they are listed, the Chief Justice does not empanel. Now, when a plaintiff issues a writ, and then he is waiting for the defendant to file a response, a defense, there is a time limit within which the response has to be filed, the defense has to be filed. The plaintiff knows this. So if within that period, the defendant doesn't file a defense, he has every right to move the court for certain reliefs. But before he can do that, he goes to the registry to make a search to find out whether a defense has been filed. If he finds the defense has not been filed, then he can go ahead and move a motion for judgment in default or whatever. But that is what a diligent plaintiff does. So if a plaintiff issues his writ, and then he's told that it has been served, and so the defendant is supposed to file his defense within this period, then he goes to sleep, waiting for the case, the defendant to file, and he doesn't file, and then the defendant now comes with application for extension of time within which to file defense and all that. The defendant, the plaintiff, who at this point in time may be described as being indolent, cannot be heard to say that the Chief Justice is not empaneling. The Chief Justice doesn't Seriously, but for the social media phenomenon in the social media where lawyers put writs in the social media, the Chief Justice may not know of any case we may not know that any case has been filed until it is listed and he empanels. So he may not even know that somebody has filed a writ, somebody has filed a defense, or somebody has filed anything. But these days, because of social media, some lawyers, even before they file the writ, they put it in the social media. That is what, but that is not official. A Chief Justice cannot start empaneling, assuming it came into the papers tomorrow, that these cases have been, they are ripe for hearing. The Chief Justice cannot, on that strength, empanel judges. The Chief Justice doesn't deal with the social media that way. So, if any lawyer, worth his salt, makes a statement to the effect that the Chief Justice is not empaneling persons to sit on a case because of something he stands to gain, it is rather mischievous. Then it is tagged with, the statement was that the Chief Justice was in a hurry to empanel persons to sit on the application for injunction. When you file an application for injunction, you are given a date. The return date is there. So it is ripe. So it is ripe. When you file an application for injunction today and you fix it for, let's say, a week's time, what the registrar is saying is that the respondent will be served immediately and then he has to respond all within that time. So when the Chief Justice gets the application, he starts empaneling based upon the return date. So it's not as if the Chief Justice is in a hurry to empanel for applications, but wasting time or refusing to empanel for substantive rates. The substantive rate is not ripe for hearing. It hasn't been brought back to attention, and I cannot empanel judges for that purpose.
Thank you very much. I think that I'll convey this teaching and procedure to the minority. I'm actually asking the questions on their behalf, just so that they see that we're not running away from anything and we're not afraid of anything. I mean, and that was what I kept telling him, that the same issues that you want to do press conference and not give the person the opportunity to respond. Sit here and ask the person, and he'll give you answers, because I'm sure he's capable of giving you answers. And so I've asked all the questions, the critical questions that was the substance of their statement. And clearly, if they were sitting here, they would have seen that they really have no basis. And, you know, at most, clearly a populist gimmick. My Lord, you were involved in this case of Adomako Anani versus Nana Owusu Agyeman. I think you, Justice Wood, then presiding CJ, Ansa, Yeboah, and then Akamba. What is interesting is what Justice Wood said, then CJ, that the often quoted legal maxim, justice delayed is justice denied, coined by the British politician William Gladstone, is no mere cliche. The right to fair trial is in a timely manner is neither a courtesy nor a favor, but a fundamental right. Protracted delays in the administration of justice impact negatively not only on those who assess the courts, such as the victims of crime, accused persons who are acquitted at the end of their trial, parties in civil proceedings and their privies, lawyers who practice before the courts, but indeed the entire justice system. The judicial history of this relatively simple family-related land matter, which was commenced in the High Court Kumasi as far back as the 4th of April 1974. 1974 provides an insight into the harmful effects of systemic delays in the administration of justice. Regrettably, it has taken 40 long years, a whole generation, for this case to finally find its way into this court, the court of last appeal. We hope court business shall always be managed in ways that will not occasion a repeat of this parody of justice. So this is a case that lasted 40 years. It was a simple family land matter, and you were part of the case. Today we're still talking about delays in the administration of justice. In this age of AI, have you considered how to use technology to quicken the pace of the administration of justice and the resolution of cases?
Thank you, Honorable Chair. I have forgotten the facts in this case, but I mean, you are not even asking me about the facts of the case, actually. But were there any dissents?
There was no dissent. It was a unanimous, I think, decision of the court.
Yes,
and
I mean,
the court was happy that they had finally resolved the matter. It was basically a land matter, but what really happened was that the judges at the High Court kept changing.
Yes.
And so the issues were whether or not, in the light of the changes in the judges, whether the proceedings of the previous judge should just be adopted, or whether or not the case should start afresh. And the judges just kept being changed until finally the matter went to Court of Appeal. And so it just lasted 40 years. That's the most important thing, that this case lasted 40 years.
I get honorable Chair. I think this is not an isolated case. I mean, it is far. I mean, I can't talk about 40 years, but what honorable member means is that it lasted for so long. Yes, I remember I had been cases like that, and I remember there was a time the honorable Chief Justice.
So basically, my lord, let me just go straight. The question is what are the mechanisms you think? You've said a lot today about how to deal with, ensure speedy trial and etc. But there are structural issues. We have about 5 layers or 4 layers in most cases. When cases start from the lower courts, go to High Court, then the Court of Appeal, to the Supreme Court. That's about 5 layers, okay? Now, can we just reduce the layers? Because the layers mounting up to 5 do not automatically guarantee quality outcome.
Yes, I mean, Honorable Chair, I agree with you, but it all boils down to the rules. It all boils down to the rules. The Constitution gives a person a right of appeal all the way to the Supreme Court.
So can we change the rules and say we are giving you just 3, attempts to get justice?
Yes.
And if at the 3rd attempt you are not satisfied, you just have to live with that, and rather work on the quality of the courts, so that by the time you do 3, anybody looking at the outcome at the 3rd layer can confidently say that what you've really gotten is justice, so you can't waste our time and resources. Yes. Can't we just cut down the number of layers?
That with all due respect, that will be the role of it will be your mandate.
Yes, so because some of those provisions are entrenched in the Constitution. So these are issues that I've raised with the current committee that is working on the Constitution review, that I think that we should cut down on. And then also, can we say that the Court of Appeal should be the highest appellate body, whilst we have the Supreme Court actually serve as a constitutional court?
Absolutely.
Because there's too much caseload at the Supreme Court level,
Absolutely.
which has necessitated the appointment of so many Supreme Court judges. Because I'm even advocating for a panel to sit in Bolgatanga near Boku so that I don't have to travel far to have access to justice at the Supreme Court level. Can we just transform our Supreme Court into a constitutional court like the US, like South Africa has? What's your thinking? In view of the discussions going on about amending and reviewing our constitution.
The Honorable Chair, this is a very interesting trajectory that this question is taking. People, in answering your question, we'll have to sway into why the Supreme Court, whether the Supreme Court even needs that number of judges. And it has been said in several fora that I have been, that whether we have a Supreme Court of 10, like I'm 9, like America, or we can go to the minimum of 1 plus 9, that's 10, as our Constitution provides, and not go up. It's dependent upon the jurisdiction of the courts, the Supreme Court. As you rightly said, in South Africa, they have a Supreme Court and they have a constitutional court. In America, all the states have their Supreme Courts where cases civil cases, whatever, can go all the way to their Supreme Courts. But when you come to the Federal Supreme Court, it is for constitutional cases alone. Now, in Ghana, we have 7 different kinds of jurisdictions. Each one is as heavy, carries as heavy load as possible. We have supervisory jurisdiction, we have appellate jurisdiction, we have original jurisdiction, we have jurisdiction to deal, review jurisdiction, we have appellate jurisdiction as far as the chief tracing matter is concerned, and we have jurisdiction to deal with presidential, and then we have supervisory jurisdiction. So we see at every point in time, and the Supreme Court is made up of very old men like us. So you see, even one of the very first things that every Supreme Court judge, one of the very first things that you say when you get to the Supreme Court is, hey, I thought I was coming to the Supreme Court to relax, not knowing that this place is even busier than the Court of Appeal. It is a statement made by everybody who has passed through the Court of Appeal. The Supreme Court is so inundated because we deal with cases, as you are aware, there's a criminal case, Ali Kasina, started in my village at Goso, and it ended up at the Supreme Court. We have cases, several cases involving land, and it starts from the Circuit Court to the Court of Appeal to the Supreme Court. We have magistrate court cases from the magistracy traveling all the way to Supreme Court, and we sit on them. So this is where the problem arises. There is no way you can have, if you decide to stick to the 10 persons, you have only a panel of 2 panels, and only 1 panel when it comes to constitutional cases. So you can't deal with all these cases. And believe you me, because of the rights attached to, I mean, granted by the Constitution that a person has a right to go all the way to the Supreme Court. People are prepared to, and now, you see, now it's even easier. The Court of Appeals are all over. In the years gone by, people will think twice if they have to come to Accra to do appeal cases. Now the appeal courts are right in their region. So they will file their cases there. Then if you are doing a case, the slightest thing that anybody does, interlocutory appeals, you are going to the Court of Appeal. So when it comes to personnel, it is difficult to, as it were, say that numbers should be reduced when it comes to the Supreme Court. Now, your case, the case that you have mentioned, if you look at it properly, if you read it, you will realize that it spent, if it was 40 years, it took 40 years for it to be finally addressed. You will find that about 35 of that number of years happened in the lower trial courts. When the cases that come to the Supreme Court, appeals don't take up to 1.5 years or 2 years. The Court of Appeal, they say it. The simple reason being that by the time it comes to the Court of Appeal, by the time it comes to the Supreme Court, then we already have the bulk of the record of proceedings prepared. And then at the Court of Appeal, it is written submissions, just the written submissions of parties, and then the ruling that is added for it to go to the Supreme Court. So preparing the record of proceedings doesn't take so long. But at the trial court, because of the number of changes in terms of judges, and then in the years gone by, parties had the right to object, to say that no, in the years gone by, both parties and the lawyers had to agree for the proceedings to be adopted. If one of them says, no, I don't want the proceedings to be adopted, then it has to be started de novo. And then even where, finally, even where proceedings were supposed to be adopted, you will find that the judge might have retired, and there are some judges whose handwriting only they could decipher. I mean, some judges were writing like this, like that. So you find that they cannot, nobody can even read their handwriting to be able to type it. So in the long run, they have to start de novo. And so if a case goes through 4 judges, you know, that one alone is enough. But as I said earlier, there must be a way of tracking cases so that cases that kept so long on the way should be fished out. In the time of Justice George Wood, I remember she caused some judges, some cases to be selected. There were about 20 cases selected, and he selected some judges. I got 3 of the cases. And these were cases that had been on our books for so long, like this. You see, when the cases were given to me, in one particular instance, a file as big as this, it was scary. But I tried to take my time. I had been assigned by the Chief Justice. I tried to take my time to, as it were, arrange the processes to filed. By the time I got to the end, the file was as thin as this. This file, which was as big as this, carried more than 100 hearing notices. More than 100 hearing notices, all piled together like that. So by the time I selected the statement of the writ, the statement of claim, the defense, and then what did they call it at the time? Application for directions. We had a very thin file to go on. Then, one of the things that also lead to delays is the lawyers. When I was in practice as a junior, if there is a case that is going on appeal, and it is time for you to settle records, your senior sends a junior to go and tell the registrar the things that should be included. But now, lawyers don't go there. They set their clerks who go and tell the registrars everything. So everything should go into the record of proceedings, the compilation. Somebody has filed a writ at the High Court. In the course of the trial, he has filed an application for injunction, to which he attached so many copies of other documents. And then there was a response. They heard the matter. There was a ruling. That was an interlocutory injunction. The case has ended. It is going on appeal. If you are prepared the record of proceedings, do you need to include the application for injunction and all its documents? But all these things will be included, making a very bulky record of proceedings. And it is the clients who pay, for the parties who pay for the record of proceedings. And each record of proceedings, each page is sold at a price. So you find somebody's record of proceedings, about 7 volumes. You decide to go through it, and you can actually reduce it to about 3 volumes. Particularly in this day and age where we file witness statements. So all these things add to the delay, transmission of records, and all that. But I must admit, 40 years is over the top. And if AI can help us trace this, we have to, whatever we do to get AI to do it, we should do it.
Thank you very much. I want to congratulate you once again for your nomination and to indicate that your responses have been very illuminating. Thank you.
Thank you very much.
Thank you, Honorable Leader. It's now the turn of my Vice Chairman, Honorable George Kweku Ricket Hagan. You have the floor.
Thank you very much.
More than 3 questions.
Thank you very much, Mr. Chairman. My questions are actually 2, just a view. My Lordship, Paul Bafuboni, congratulations.
Thank you very much.
Looking through your CV, I have no doubt in my mind, looking at your background, knowledge, and experience, I have no doubt in my mind, and I believe many Ghanaians, that you are the right person for the job at this time.
Thank you very much.
Now, just as I said, just a view, actually, that I want. Do you take the view that as a country, Ghana, we are churning out too many lawyers in terms of people going to law school? And if that is your view as well, because it's a view of, a school of thought, if that is your view, would you support downsizing the intake to the law school as well as those who go through the bar? Thank you.
Thank you, Mr. Chairman. Honorable Chair, I think I don't agree. I don't share that view that we are churning out too many lawyers. Actually, the word churn gives the impression that we are not training. We are doing substandard work by that the products are substandard, but that is what it is. We are also not overproducing. Actually, you see, if you go into history, throughout the whole period that we have had lawyers in Ghana, lawyers that the law school has produced, and the lawyers who have come from outside, all put together from 18th century, by all that, we're not up to 15,000. 15,000. And that is from 18th century. Out of this, a lot of them have died. A lot of them have migrated. So currently, the people in Ghana who are lawyers, despite the numbers that you see being called to the bar last year and 2 years ago, the numbers are not up to 7,000. The number of lawyers in Ghana are not up to 7,000. And out of this 7,000, less than 5,000 are in private practice. Less than 5,000 are in private practice. And what I mean by private practice is, for example, those who are on the bench are also part of it. Attorney generals, and then the practitioners. That doesn't include those who are in the banks, Bank of Ghana and other places. All those are people who are not even parties. So you see, if you take the number 5,000 as lawyers in Ghana, and you measure it against the population of Ghana, you have a ratio of 1 to 7,000 citizens. 1 lawyer to 7,000 citizens. Nigeria, they have, I think, 1,500 or 2,500. The UN sustainable is that it should be 1 person to 250. So you see, we are way beyond. We are way above what should be the right thing. And we also have situations, the law is such that the district assembly law, the local government act, expects every local government to have a legal department. And when they say a legal department, not just a lawyer, a legal department. If a legal department, then they should at least have more than 1 person. Every local assembly, House of Chiefs, all the houses of chiefs. So we have lawyers. We actually need more lawyers. If you are deceived by the number of lawyers you see in the law court complex or plying their trade in Accra, you may be deceived into thinking that there are many. But go to Kumasi. Kumasi has a population as big as Accra, slightly lower than Accra. Or Ashanti region is maybe even bigger than Greater Accra. But the number of lawyers operating in Kumasi, from Kumasi, are 305. Kofori, they are 110. Secondly, and my honorable will tell you the number of lawyers who are in Tamale, Bolga, and Wa. You see, we don't have enough lawyers. So even the number that we have a maldistribution
geographical maldistribution. So if you see lawyers, and there are so many of the lawyers that came out, who were called to the bar, the people who were called to the bar very recently, there were about 800 of them. I can assure you about 200 of them may never ever step in the courtroom. They just, the headmaster of my school, the best secondary school in Ghana, is a lawyer. And he's been a lawyer for the past 6 years. I asked him why he went to read law. He says, when he retires, which will be doing at the end of November, then when he retires, then he will pick his law, he'll go and do galamsey. No, not the galamsey. The lawyers understand legal galamsey.
Are you talking about galamsey in law?
In law, yes.
Very well.
So you see, and then of the 5,000 lawyers that we have in Accra, so many of them have run to Parliament House. They are politicians now. They don't even come to court. So my honorable chair, they are not many. As a matter of fact, I believe that we need to expand. We need to expand the admission so that, because now a lot more people are doing the LLB and they are not getting the chance to go to the law school. So there is even, there has been discussion with the current Attorney General, and then we are thinking about a situation where I think there's a government policy in the offing that is aiming at farming the law school program to various faculties so that we get rid of the admission, the entrance examination, and then we find ourselves, everybody who has done LLB can go and do the law. At the end of the day, there will be an examination, and then people will pass out. People will come out as lawyers. So to answer your question, I don't think that there are many lawyers in Ghana. We actually need more lawyers.
Thank you very much. Any further question?
Yes, Mr. Chairman. Thank you for the enlightenment, my Lord. My second one is also a view. And now let's turn to the Supreme Court itself. Ghana's population is about 34.5 million. Let's say America's population is 10 times that size. We have 19 judges of the Supreme Court here in Ghana to a 34.5 million people. We have 9 to America's 345 million. Isn't that we have too many judges in the Supreme Court? What is your view on that? Thank you.
I thought I had answered this question. I thought I had answered this question.
Honourable members, order.
I thought I had answered this question, but Honourable Chair, I have to repeat what I said. America doesn't have 9 Supreme Court judges. It's the federal state of America that has 9 Supreme Court judges. America has about 351 Supreme Court judges all over the 51 states. You see, and the American Supreme Court, that's the federal Supreme Court that you are talking about as having 9, has only one jurisdiction, and that is interpretation of the Supreme Court, the Constitution of America, of the U.S. That is, they are what we call a constitutional court. So, but Ghana, our Supreme Court has, as I've said, appellate jurisdiction. The case, the 40-year case that honorable member talked about, finally ended at the Supreme Court. I'm sure even if we were to go into archives, we will find that from there, from the General Supreme Court, the person might have gone or up for review. You see, so the Supreme Court has so many jurisdictions that if we decided to keep numbers at 9, we would not be able to work. We will not be able to work at all. The only thing that we have to, there are two things. And either we increase the numbers, 19 may be all right for now, but the way things are going, the way cases are coming up, and the way we are thinking of AI and other things, we may see now cybercrime, everything. There are modern areas that are coming up that we have to empanel judges to deal with. The way things are going, if we don't take care, we might end up with about 25 Supreme Court judges. The surest way of avoiding that calamity is for all of us to come together and maybe through the Constitutional Review Committee, reduce the jurisdiction of the Supreme Court, the various jurisdictions that we exercise. Like Honorable suggested, we could say that every appeal should end up at the Court of Appeal. There shouldn't be interlocutory appeals. There shouldn't be that. There are so many things that can be taken off. If we say that you cannot start any, because you can't start a presidential petition in any court apart from the Supreme Court. By an ingenious way of interpretation, even though all cases can end at the Supreme Court is said that parliamentary petitions can go only up to the Court of Appeal. That was very, very ingenious. And so parliamentary petitions end up at the Court of Appeal. If we could find a way of putting into the constitution that we want to craft for ourselves, so that cases can end at the Court of Appeal. Or, for example, criminal cases can only end up at a high court or the regional tribunals or whatever. Then we can start thinking about reducing the number of Supreme Court judges. Otherwise, we should be prepared for a situation where we can have 20 or more Supreme Court judges in future.
Honourable Member, do you have any more questions?
No, Mr. Chairman. I just want to thank my Lord, and then I wish him well. Thank you very much.
Thank you very much.
Thank you, honourable members. My Lord, our revered guest, it's now my turn to ask questions. And by our practice and procedure, I don't have limit to the number of questions I'm supposed to ask. However, I have sat throughout the proceedings. I have listened to all questions asked and answers provided. I do not have any question for my Lord. Honourable members, I will then proceed to congratulate my Lord on his nomination as the Chief Justice. And before discharging him, recognize and acknowledge the revered guests, which I will do not in any order, but I will start from the guest list of the Honorable Nominee. We have Director General Prison Service, Patience Bafo Boni, a spouse of the nominee. Then the following people are the children of the nominee. Sandra Elizabeth Bafoboni, Major Felix Bafoboni, Engineer Eben Leslie Bafoboni. They are the children of the nominee. Then we have brothers and sisters. Mrs. Georgina Konedu Kusi, former Council of State member. We have Peter Bafoboni. We have Mabel Bafoboni. Then nephews. We have Justice Bafoboni, Enoch Bafoboni, and Dr. Kofi Bonzi. Family. We have Marini Kwe, Rosemary Boafo, Commodore Faustina Anoche, Kwame Asaribuedu, Jefta Apao, Esquire. Then we have the representative of His Royal Majesty Otumfo. We have Nana Sampamahini. We have Nana Amantahini and Amantahini. Anantahini. Forgive me if I don't pronounce it well. Typical Aibe boy pronouncing three names. Then we have Nana Dr. Abura Boati Yinahini in the Ashanti region. You are welcome. Then we have Reverend Father Akes, Christ the King. Reverend Pastor Tete, Assemblies of God. Then we have old students of Konongo Odumasi Secondary School. We have Felix Abuaji, Esquire. We have Justice Kusi Minka, Esquire. We have Koku Chiramantin, Esquire. We have Esuo Yao Benin. We have Captain Collins Fosu. We have Kwame JB. We have Kwame Ousu. Honourable members, we also have Marietta Ajewa Brew. The legal counsel to His Excellency, the President of the Republic of Ghana. We have Benedict Bob Derry, Director of Prisons Operations. We also have Francis Omani Ado, Deputy Director General of Prisons in our midst. Honourable members, don't take offense in the event I do not mention your name. At the back, I have Nana Sangba Jafla II, Paramount Chief of Sampa Traditional Area, also representing His Royal Majesty Otumfo Osetutu. We have Nana Bofo Ajay Chichikra II, member of Asantehini's delegation. Then we have Berima Yao Koda Opong Monwurahini of Achim Ebuakwa Traditional Area. Then we have Togbi Teprehodo the Fourth. I've eaten the okra, so I can pronounce this one very well. He is the Paramount Chief of Famfoga, the President of the Volta Regional House of Chiefs. yamamu nyina ajo amamu akwaba abaye kasafidie so hi TV XYZ so enwechi no power 97.9 FM radio XYZ so wo hwe wo bre no a akasima no ba miensa pepepe na anwumre no son abo ewo efie ha enede ensamdodo no na akoso sede ye nyina ye nimefi no pa beye nondu bako ede ba ye nyina nim ne ekoso ye vetin ya ekoso Chief Justice ya boni dini sempani entnase na wontoto nano eye Justice Bafu Boni ene vetin no atimi akoso kama ene omabomu a sede ye hyase a na edom kuma ye wo mrahye na wonto ho ase kyerese wo hwa asem we no a ewo court dada entinu nenka wo se ye twen ema court no ede na temu ahodo no nyina ba ECOWAS de enu achuba Ghana ha se ye Supreme Court ne High Court de ne nyina no ye nya temu bia mfrimu ena ne appointment committee and as vetting committee no akwa asetena wo se wo toto Justice Bafu Boni ano de a ene na wo ntwe kra ewo committee no eso kwa wi akire no wo mo work out wo mo sorry ekoye enam so ma wani a oka ye ewo committee no so tena se atoto papa ya no ensembisa ne de ene left and right wo mato ama ne pa ama ono so anya ho bre ayia no akire se wono no de ye ka obi a wodimu obi a wosefata obi adwuma no ye de hye ne nsa obetimi aye ne dia aye ne yie dia ono ane ye Chief Justice ye Bafu Boni adwuma no obetimi aye ne yie ensam dodo no ano mbisa no eforman Ghana yatamuo adwuma eni emunsem ni titru okwan befa so AI ni munsem ye betimi die ye adwuma ewo yatamuo adwuma ni kwan ye befa so ama asem beto court a ebetimi akoso ntentem edi amayen ehun emuaye ni nyina wode baye ekire na adwene ewo ho asese die ensemisa ni nyina akwawie ya free china ekono ye behunu committee no report o beba de befimu aba de bekosi bia no ehun nsem no ye de besom etina ye begina so na enwumaku ahodo aya na omo so yasene eme de ye nwumre no nsia kasebo ebrem no ye de aseda piesie amome ne amapoma chicheku ene wo hase ya ye de aseda ema nwumaku no
ye da ase de ne mfa bi enkoma power specialist eba hospital wo mo yatena ye ya wo boa ma ya de ahodo ahinte ni padua na kwa baby mo no wo mo boa me etu ase wo se obi hepatitis B C A ne hawadwe no wo mo na wo so ba no mo boa e de aduro kan wo ema ne kro afi se oliver na ho no aba ho na wo ye ho hwenye ya wo brebo no ho na ba ho na de ha wo bre wo ni padua no a wada ma power specialist bra wo mo hweye na wo mo enhwe wo se yemkro ana fibroid na tete wo kidney stones ene no sugu ye mo hweye ho na wo so ba afi power specialist se emema mo mema yo se besi pie na gina na so nti ene odi jirikagiri eye memedro tatahwe mema ne di ho adanse pa wo mo de aba adwama so ya gibinom na emwansiesie oni epe immune booster dia na hebatin mixture eno so adwama so a ebeboa asiesie ma immune system no enya hode ese efata no nyina wo pharmaceutical shops ahodo ye wo Ghana hase akwa benya bi na wato enkran wo mo kwabenya ACP kwantempo no so pa bus stop sa na efre ho enti ebesi Kumasi fe yi ase bosomtwe kwa so edo aya junction odu anu wasi kama obehu se wo bo signboard ne wo ho ede wo kɔ ho ena fe takrade Anaji Estate wo mo ben Hantamai Rural Bank ne bibini abetumi afrem penny 402445444 4420244 544 from penny 4 wo mo enu bedin kita ho
na mensa ka promo no eguso ekoso ne wo se wonya sika edigu botom enti de ehia ne se ofa mobile phone no obe dial *274# *274# udi hyehyɛ ne so obe select Power FM wotwa ba ku bia no a 5 Ghana cedis spent udi adodo bia wa ho ɔden besoso no na watwa gu bebre sika no be 50,000 Ghana cedis ubedi ede agu botom na hya ne so se NLA Caritas platform no wo mo agye atum nti we no enya nkwanche gro bia na emom no nyamru mfihia edunwotwe a wo nka ho memfa ho enhyem kura enu achi no mu amaka ni nyina no mutimi edi saa gro bi ema wosusu nya sika edigu botom
yemfa ye ne nkyere solar natural clinic wo me asue ya won so boama apomde ho nsem etumi afa ne ntoma pefa Dr. Solomon na pamfo de odu solar kasue ho a won be hwe kama na enema nyina etimi akoso yie wo se adwunso mu hawo ho ene tete wo ananso process sem na nyina yie etode bi edu anajo ana ho asem na etare dia ma wo den na woje ho ba bi a enya ya no aba so like for ashe no maboa ade ba ko asese nso omo ye ho ade pa esese wo sa no ho aka na mene ahonhono na aba unipadua ni mu na se tatai wo furu hye wo ye ho hwe nya yi a wo se bra wo sa ne nkwa problem de obeyi afiri o ma dialysis ho ka ne nso abedua wo so no ne nyina ebe free ho sa nso na amre bo ne nso amene nkrofo kasa watro enso anyensa no wano mu a wo se ne nyina na fa beda no na omo ase de be ya wo ho ebetumi esa wo ene obi ya wo ho ana na asia peja wonim de kodie ntia ya na akwakoye ne sa no wo de dru so like fo aso ya wo mbebo obi nso ho edru anajo a woni obi aka o ne nso se be ya obeda no na eno nso so akwakoye bibie ho wo na asem akoye tare obi timi tena ho no mbe se de ho na nani mo ne dwempo na campus wada ne nyina ya hawa wo de dru so like fo wo mo ahwe ho no mo a wo mbehwe na wo maboa etu ase edi ama wo se nam yade ahodo nso a wakotete asrasa ne nyina no brane draw hanim di fo ho ya do be fa mfidie mba bi o ha ne wo ene edukwa yemfa hwe wo no na wo mo ahwe ne kama edi ama wo betumi nso akọ ehwe se bia wo yoba wo fibroid na so kra wo be ma wo prostate ni bia kone enya scan kama ni ehunu ha ni bi ni ho a wo so bi ho a na wo maboa pedro edi ama wo enkran hadi kokomlemle oba Harvard Senior High School ya for Dr. Solomon 0553932631 0553932631 ofrenwa wonsa bekano
na Medimosis Diagnostic Center sa yen kan kire atiefo ne ahwefo nyina se opa ya sabia papa no obeye hwehwemu e wo nipadua mu dia eno ane Medimosis fo akache oborwamu a ene wo nipadua no mde mfidie ahodo besi so ayemu hwehwemu ba bia ade ne hye bia no wo mbehunu wo hunu so obeboa ama wano aduro enei no bibi ti se wo liver no ho test no omoye bi ene bio nso so no kidney function test no eno so omoye bi e wo ho enu achikra no cholesterol profile full blood count no moja sam no senetie ewo nipadua mu ewo nipadua no Medimosis mpanifo se oba won benya ho abotre ayesan hwemu no edi ama enu achi mema no mo prostate no emu nsam no so yade ehu hia pa Medimosis mpani se memfa ntena ho to anamobra na wo hwehwemu kama emfa ema urine analysis ojunso mu hwehwemu no won beye enu achikra moja mu hwehwemu no ni nyina won eye ne kama digital x-ray any dental x-ray ni nyina no won mu ye bi ewo Medimosis Diagnostic Center eni mani ya won se bo anaye na fa ya de ne bedan won na won achi kwan no won dental barrier woni post station no eni di enhwe ni mo ewo nkran ha ya wo betimi afren homa ye didi sui eye 0503 494885 and a bio 0244 068447 fra Medimosis mpanifo ebejoso.
And is how the best garlic mixture where drama soa ye ni peduen mun senchenia na a 3p garlic mixture drew way a garlic and casa 100% ya train a hunsuo no yemfan keja nenso drew we ko ni peduen ma wa ten kasa mpa ni peduen sisi ne ho so ama wa ye kama papa eboa bosu immune system na mo ahoden e ma nya na agina so a wotimi de bo adwuma ya wo mre ho ni peduen na tutum wa poso no wa poso ye ho hwenye ye ya na wonsa no nan ayo tititi ananso nkrofo keka so ay kesi abroso etoda bia wodwonso sem na bibie wo furu no wonim ni abemu nso hona na ehono kesi a na eye wonim ba bia firi nkrofo se eskefuru nso wa hwa woni kapre na wanye skefuru ananso yo bia etoda bia na se bre wo so stress no ni ate a oda ma waje nkwa ene 3p garlic mixture droway okọ kofisam okai shinom ene kings work mo a wobenya bi wo ho no watu tema community 5 little George ho se okọ a wobenya bi wo ho Madina ene St John's nyina okọ a wobenya bi e wo ho na wato eye piwak natural health for na akofedre de abadwama so ba wanyinsa akoda woni mfie dumie ni wo nko am ene ni ho kwa se drowe wo mo efabie na ya hye ne so se dro no ene yi nkrofo ahyeda de asokwa da ne nkrofo akyenkyena ene nti hwe no wa ma obi entwa kotokro amfa ma kire se ye 7 nti se uto adro ne bia ya hunu se eye ni ti no eye ye de etire kokko ene ye de abua so ena eye glass bottle ene ye de agumu se de be ya obi ena da won kofa bibia emfa mre wo bibi ni afre 0248928824 0248928824 and 0201 000 021 no fra Piwak Natural Health in Penifo ebejoso.
Little George Health Shop say yenkacho say adro bia upe bia no uboremu ewo Little George Health Shop a ubenya biato wo de wachia bre enro no de atua na monwa kwa pharmacy shops ahodo wunya bi ntwa borem ewo Little George Health Shop na kwaje wo de wo mo Tema Community 5 in between Presbyterian Church no ene PV or being runabout no ene uboremu a bibibia te say kowa mixture no anase kowa plus mixture ni nyina benya biato Dominion herbal powder Mr. Kill vitamins minerals any herbal foreign medicines ni nyina no upe biato a emfo wani nche bebia eno ane Little George Health Shop na wakwa kwaje wo de na wo chese turmeric no ni ginger blueberry juice ni aloe vera gel ni nyina no wo mtuntun bi e wo hono a woni ema no ye papa wo de adro bia wo pe no de hiane se obetu anamon na wakwa Little George Health Shop na wakwa kwaje wo de sanse ho eno number 1 health shopper de ope bia no ubenya bi o kwa wa kwan na munchemu bia no a na wafre 0243 140213 0243 140213 ofra one more ebejo so
ene malaria kawa to dem ma ya ho hwea enye yiye typhoid na akwhwe omugye mu yesesese wanya typhoid wo ha wo tete unhu adukura wo no mu a ebeyi sa ha no de afiri am yenkamfo ruta natural product ma sa product de ho adansidie wo ho papa ya nipa dodo na ya no ruta wo mu no ni bie no wo mu di ho adansie ekase so de people say e adu papa eboa ama e malaria ne typhoid de ase etu obi ho apese ni pedua no wo yi fi ni ade afiri mo pedro bia benum a ebe detoxify wona ni pedua na nya kwanya agina ne ho so na sisi ne ho so kamade a ene ruta life eno ne wo se kamfo de ma wo na onu biem belly fat ne be na ana ne nyina na afa yefunu no ada ho na afa ni pedua no so atumi na adwuma se de se na efata ene pharmacy chemical herbal shops ahodo nyina mu kwa ubenya bi atone bia na modie mo hawo ya motawo ye typhoid e wo bufia bra na betu bi na ubetu bi afre Dr. Abenin Penny 0244 503443 0244 503443 o friend Penny 4 wo mo ebeje so.
Let's talk educational consult Madam Time Bomb eno no woto nsafra wofo nyina se momfa mo manemrai na o magentete e wo nwuma sua mu ene preschool admission ekoso efiri bosumi nsia na akopem mfie nsia bibiti se study day school no ni nyina akoso entrepreneurship reading writing personality ni development ni nyina personality development IT ni nyina obowra mu wo Let's talk educational consult obenya ho adaje na wachre oba no kama ama wabaye pabene ankasa watete ani ntrani ani mpon bebre wo Ghana ha senti wo so wote hono egedien bibiti se training creativity any exploration nyina no ubowra mu a wo betro kama consultancy any teacher training no wo se for abane bre na wo magisa entsie we nyina na won machi kwan no wo tashi Nungwa Estate Mango Street no woni Lejokoko Municipal Assembly no na edi enhwani mu nti wo befra homan na wagimu enchemu 0249 069821 0249 069821 ofra Let's Talk Educational Consult empany wamo ebejo so
ebusua ade baako a eyo ha woni pedua ni mu a eya pa wo mu anya bie no ya wo mota kasa de esi etie yemkuro ya ye friend brofo mu se osa etimi ma obi so te etimi ma abofo aduane kra anya ode no anu mu ato oyo ho hwe nya yie bi wa wudidi a na se aduane no esan ayese pese ba ejejejeja obobi oyo ho hwe nya yie ebi so kra ho a na se ama wonya heartburns nom sa ne nyina no osa ho sunsuanso ni bi wo ha na ode unya koma doctor nkan kire wo se osa na emu wasta kire wo hu se nsunsuanso yi bie se de woni padua mu a na wabomodin a na wape haxa mesha woni ni nua capsules ne be na wano mo betumi afa ne nyina bom so ho nom capsules na wonom ye friend say mesha no de ka ho nya sanso a wo fa ne capsules no na wonua bi nso wo fa ne mesha no nso wo bie na aboa se de be ya ye betumi yi sa ha we de afri ho haxa mesha de all satanfo ene nti ne wo call pharmacies ne chemical shop shops ne herbal shops ahodo a wo makwaje ne chapodi egu we san se ho adansedie ne nyasem keto nti bomodin ase wo behwe no agi bie san se FD4 wo mo de mo stamp a team so agi atum se ye du kroje ya wo no mu a oha bia ni ho ebeba ni padua mu nti na wo call air cars pharmacy e wo Madina wo benya bi Repash Ventures ne Halos e wo Kaishi Drug Lane wo benya bi Tema Little George ho bi wo hoju card e wo Kaswa open dudu mu so anu afrem penny 0240238310 0240238310 and 0203822855 ofra na wakoji bi Haxa Mixture or Satamfo
Ostic real estate was se beji asase a mansu bia eni ho nei o to asase a no wa pepapa de ho nkratasem no eye papa na edimu wo kina bi no ho ankwanko basem amfa ma na nunti ene nei ni Ostic real estate fo chese wo mu asase bebre ho nkratasem no so ejane nan so ntu pe bi wo ba bi ti se dodo wa ayikuma asebi doyumu afienya dowenya anase Shy Hills a odi ebre asase ne ho te kama oba obenya ho nkrata mansu bia ne ho nye obi asumasi langas asem bia etikọ na kwaje ode no so hyase na your project bia peso ye bia ewasase no eso obefre Ostic real estate for ewo 0244 684069 0244 and ebio 0240 933748 and 0266 101406 ofra Ostic real estate for ebejoso
yemfa unkoni yankoma Spanish garlic mixture and the capsule said the baby boa ama onasia peja no akobi wo ho a o dwonso na okoba ya fe na fe dwonso sa de ne biem ebi kra wo abekọ be try dwonso ne nyade ebeba ebi nso kra wo abekọ ne ko na so na wasa sign aba betina se wonu wachi kra na dwonso na sign ho se epese ebe biem ya na ha ebi kra wo ha dwonso no mo hunu wo ma ne beba mo ho so ana wa na ne nyina abesene ko eyo how kese pa na emom Spanish garlic mixture and the capsules wo ho a ebeboa na di wakagine mu na isa ha we di free ho ya na no mpem joint no etetutu arthritis no de ka ho ha wadwene ananso ye obi abu nsa bosome a ene wo so na nkrofo hwede oje bosome akatua ne enso waso isan se wo kemo ho a wadrop ha and Spanish garlic mixture and the capsules kese mro so ana okobia na akocheke so cholesterol ne wo so dodo e wo se ba fam a wadra wo no mu a ebetumi amana ba fam no ananso ya na ne nkrofo kasa wo mo twi wo mo ti de friend halitosis ne bia na se eyenum nka no bo modi anaji se drebi na enom na emwa wo enega na ha pharmacy shops ne chemical shops akese bebi etu no ton bia de okọ na bodin se wo Spanish garlic mixture ne capsules ne bia ye beton obi dia ma open dudu mu a ya frame empeni 0246114111
na momo mensaka promo no eguso ekoso we momo mensaka promo no ena ekoso na nipa bebro apem ena sa promo e wodo ho ahyem a wo madi nkunum abribia wonya sika edigu wo mboto mani ebi mu enya free be 100 Ghana cedis ekobe 200 Ghana cedis ya we nom eye ikasha ekoso pa etu betimi edu ho ahyem bi na wo kyese we no obekoso aye transaction ewo MTN ye momo app no eso abribia wo de so na ya transaction e wo so ubenya sika be 100,000 Ghana cedis ya no ye chese sika twitwiri die eno wode e ma wo e wo sa promotion yi emum eno no chese enye se sa transaction nko a ubetimi aye bi se bia obe transfer sika afri o mobile wallet no so dia call bank account ana so di free bank account no so e ba o mobile wallet no eso wo ye savings ana se bia loans investment any one ya wo ye pensions na sefo ni nyina no ubetimi edo ho sa adwumadie mu udu hu hyem so a abribia obenya sika ade agu botom abusuana ha ne ade nyina besie da mo se monya ye ho abotre ne ama efiti anopa bremu a ye sha se de bedrum pempensoe muguso amokurekura ye chinyame yadma wo chena so eye da foforo esanse ehwani mu se Ghana mampani ye John Dramani Mahama sabre se ne nsa kankrata no a wo chena ye bebo mu dewura me yehuno hwehwemu a ye de fa wie mu hyen ya na no koteto ye oboase kwan mu me ko wie chi Ghana yakatachie mako wotwe wo mo ehwere wo no enkwa no wo chena emu report no sa ene ntia ye nyaye de fi mampani atena ye se ye de
emu nsɛm ba beto abɔnten ama Ghana fo nyina ehunu bi nti so ɔdomfo de ade pacha ya ɔkyene a yɛhwɛ animu sɛ sɛ nkitahodie enso so betumi aba so nkokɔ nketenkete nso yɛhwɛ animu sɛ na wɔtwe mu ɛno nso yɛhyɛ aseɛ nti mo amadaka mo nya mo boy ya mo de beje nkokɔ no ɔkyene ya mo nsi nkrɔfo so sɛ nso anadwo ya frɛ carpenter ne sɛ wo me bɔma na ɔkyena ade akɔgye nkokɔ na ade abegum wahu no atete wo ma manyini na afa yɛgya nkokɔ fo su kra na boa mo man nso so etumi enye sikapudu ene ade de mo si ha ne ada production team no nyina ACMCR director Rafo ho ene de Kelvin Asante nso tiechire saa nso na mama Peter ewo ho ena afa Imanete wono so sound no wo hwɛ sɛ bibia beko yewuli you have two parties one eye Osofo Prince cameras yechi wo mo so ne wa ha Marjorie and afi Agnes wo mo enso ne boy chidom every newsroom Lizitegu as usual ono ne makeup artist enwumre na yen so a ye betwa ye ho kakra mu amo me amapoma checheku mene
da chima akosia oforiwa amanfo
na ya obeyi a oda forma so ne yafunu emunumuni.
Oh Mr. Entry also yare ya titi be benfie pi nanso ne yam nyono da se me chew no ahodo amato a me hunu hwe a ebe ya nwanwa
menyi ni se what also tamfo hexa capsules any hexa mixture yanum bom kotia also no bia ma no anom anka ne ho ato no dadaada also dro de eno ne hexa capsules any hexa mixture
akom ni nkyeremu
also yekura eto yefunu ene ensunumu etuma wo yefunu ekeka wa wogire ho a enye also etumi ema wo ye cheko ebra wadidi awie so how eye also de a compare hexa capsules any hexa mixture nanum bom na ho ebeto
pedudu atu a ko okanshi drug lane Kumasi Dani Herbal Takradi AA Mensa Anafre 02038228855 Apefo abatanya woma won mofra no fo ene mofra woni mfie dumienu enka ho Haxa capsules ene ne mixture
all satan for edie age adwadie nkrato yi atom.
The average human body mass should have at least 60% water for optimal performance in any physical or mental exercise. We can help you maintain it naturally. Natural mineral water. Simply natural. For bulk purchase, call 0596 273 546 or 0596 273 547. This advert is FDA approved.
If I'm not farming, me a taxi dollar. Now, and can I Mississippi? If so, Mississippi, I'm not coming out to net to trim. Began 3P, Garlic Missano. I want me.
That's a miracle. We were doing just a full prayers and you see Chimney and Casami is to me. We are lazy. Because the dear baby Shemi Subino, Noma, you kill me, be community prime is very destiny. I don't know that the young body. I be on what you might be. And yes, I'm going to answer with a metro catch on a Mayfair Shaman Kwana.
Mediabe, 3 years. Ana asemi gina wa me mu sisinya se me kwa we dia me ko bia mu so much me dru da ba 6 years ni o tema bia me ya ma ji se ne me ja na ta ya le ne nku me preko ene 4 days ana me koto 3 garlic mixture ni tema me kase yanku pe no yam se ende ya me no kase me wa to me a me din wa me ntia se
3P garlic mixture ubenya bi wo mamu pharmaceutical shops and herbal shops Fred Piwak e wo 02489288824 and 020100002.
Welcome to Auto Check Vehicle Diagnostic and Licensing Center.
I hear my car can be checked here without going to Accra.
Sure.
Emission, check.
Alignment, check.
Brakes, check.
Visit Auto Checks at Koforidua Aquadum Road for the road readiness of your vehicle, from saloon cars to heavy-duty industrial vehicles. Madam, your car is now ready for the road.
Thank you so much. Auto Checks, check.
Auto Checks, your safety, our priority.
Check, Auto Checks. Missy Menanum, a group pass up, I've been bragro to be doing Lenu.
As for me, I take very good care of my grandkids. Ye dear grow, na yes, a do maybe crana, me bano timide, or maybe gumi so weekend. Hey, remember, I don't think I'm a catcher say, Yano Medi garlic capsules. Posun, a basis so come. As I stand here, my doctor said my whole system has improved very well. Medi garlic capsules, yes, Medi garlic capsules.
Medimosis garlic capsules. Boa mamoja dini paduani mu efurusani ye na esiesie oba ne barima mahona wodin. Ubenya edoi bi ato omanyi mu pharmacy store frey wo 050-349-4885. Edoi enye mamofra enye ndi fie dumienu apemfo ene emma emanofo. Medimosis wunni how FDA ajije din kratui atum.
Hi, I'm pleased to introduce to you Cancer Mixture, a herbal mixture for arthritic pain.
Arthritis, it's me.
Cancer Mixture, no, Cancer Mixture, no, Cancer Mixture. Yerba Biana Nudruo, Moria, or arthritis. Cancer mixture, obey your juma when you put your inside. I'm a pace in the grand. And in Fidiana menu, on your market for in your button, I want one menu for. First, baby, I'm from one Sanka, Senior Susan, Boliviara, home doctor, and I report to FDA Med Safety App Nodo.
And Gratui, FDA, App Nodo.
Muntie, ye watch your channel, Afedie, LPA, or Yania Hochano to Mega Cash Lucky Box, and a bit Diwe Hujuma, where your game will be disca, instant cash prize. For phone number short code, *426*5#, and no, a packing crime. Mega Cash Lucky Box, and your name crash out beto. Dial short code *426*5#. Our all network. Follow prompt no. Net choose Lucky Box. Never see cash chemuno. Nina ya wodia. We bet near the 500,000 Ghana cedis. Ane 5 billion. Siano sisa sanshi shei. NL Ajiatum. Our Caritas lottery platform so. Mshishaka crow.